The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, we are prepared to hear International Painters versus Florida Glass, and Mr. Siegel.
Good morning, Your Honors, and may it please the court. Peter Siegel for the appellants. I've reserved 5 minutes for rebuttal. There are 3 key facts in this case that I'd like everybody to, make sure we're on the same page about before I sit down this morning, and I think they're sufficient to resolve this case in my client's favor. The first one is that, as is undisputed, there was no point during the arbitration window before the arbitration deadline at which my clients would have had any reason to raise any statute of limitations issue. The district court acknowledged that fact, and there's no dispute about it. So we could not reasonably have been expected to raise any statute of limitations issue during the arbitration window until long after the arbitration deadline closed.
Well, why do you think the suit is time barred?
Your Honor, my clients are
it's not time barred.
So my clients believe the suit is time barred because the proof of claim in this case was undisputedly filed more than 6 years before the claim. And so the key question in this case is whether the proof of claim was in fact a notice, demand, and acceleration of my client's withdrawal liability. And that brings us to the second fact that I wanted to mention, which is that my opponents, the International Painters, accepted a bankruptcy distribution based on that proof of claim.
And all that depends on your view of what a proof of claim is.
All of that depends on whether the proof of claim was in fact a notice, demand, and
an acceleration.
An acceleration, yes.
Okay.
So you're saying that every time that an ERISA plan sponsor files a proof of claim in a bankruptcy case involving an employer, that necessarily qualifies as a notice and demand for accelerated payment?
So, Your Honor, that is our position, but I don't think you even need to get that far to rule in my client's favor, because in this case, the proof of claim led to a roughly $48,000 distribution from the bankruptcy estate that the fund, in fact, accepted without objection. And they have offered no way to reconcile their acceptance of that $48,000 distribution with the idea that they weren't demanding withdrawal liability. So it's undisputed that that $48,000 distribution was based on the same withdrawal liability.
But how was the filing an acceleration and default? How do you square that with the language of the statutes in our case law?
Sure. So the MPPAA provides that in the event of a default, it is optional for a fund to accelerate or not. And I think that's principally where your question is coming from. In the bankruptcy context, and I think it's important to mention, the MPPAA and ERISA make clear that where there is a conflict with bankruptcy law prevails. In the bankruptcy context, it is simply impossible for a 19-month or a multi-year payment schedule to be the means by which the withdrawal liability is paid. The only possibility, because of the priority rules, and this is in both our opening brief and our reply brief, is a lump sum immediate payment. And that's in fact what the proof of claim led to in this case, was a lump sum immediate payment of $48,000. And this gets us to the third undisputed fact that I wanted to mention, which is that the only reason that payment was $48,000 and not the entire amount of the withdrawal liability they're suing on in this case was that Florida Glass's bankruptcy was underfunded. So the proof of claim led to a bankruptcy distribution that was a payment.
Your major problem, at least what seems to me to be a real issue that we have to decide at the beginning, is the impact of the MPPAA, which requires this to be in arbitration. And issues of procedure, timeliness, statute of limitations go to arbitration. I mean, that's what Congress intended this to be. Is that correct?
No, Your Honor, I'd respectfully disagree with that, and even the district court, in fact,
What are you
disagreed with
disagreeing
that.
with? What are you
So
disagreeing with?
questions of the statute of limitations are for the court, not for an arbitrator.
What court has held that?
So the district court in this case held
No,
it, it's
I'm talking
undisputed.
about what other court,
And
my question is this. Congress set this scheme up for a specific reason. That is that you had to go in this particular route to do this. But is that not something that is to be arbitrated? Aren't you required to arbitrate these claims?
No, Your Honor, and if I can answer, we have a long string cite in our brief of cases in which courts, not arbitrators, have addressed statute of limitations issues. And the reason for that is that the deadline to arbitrate issues arising out of one of these notices and demands is months, not years.
I mean, you seem so anxious to have us address the statute of limitations issue, but I think there's some real problems that you have in trying to prove that the pensions lawsuit is time barred. And I have problems both on the demand end and on the acceleration point. To me, I just thought the proof of claim here was simply a protective filing to make sure that that they didn't get the pension funds claim wasn't discharged in bankruptcy and then having that brought up as res judicata in another lawsuit, because the reason I thought this was a protective filing was that the word demand didn't appear anywhere in the document, and it was we see these kinds of things all the time, and it just seemed to me that a protective filing, which is also contingent, was simply meant as a safeguard against the discharge of the pension fund's claim in the bankruptcy process. And I think it would be a very broad holding to say that every proof of claim was somehow a demand that set the statute of limitations running. It didn't. The word demand did not appear anywhere in this. What I think struck me as a protective filing.
So, Your Honor, you're correct that the word demand did not appear. There is no precedent for the notion that the word demand specifically has to appear. And by
Well, but that is at least relevant. If it was a demand, then you would expect it to be demand, because a party seeking payment, genuinely seeking payment, would want to demand payment because it's in its emphasis. It's in the party's interest to press the matter, not just to make a protective filing, but to press the matter and say, all right, this is a demand, we want to be paid, here's the schedule of payments, get started.
Well, Your Honor, the proof of claim in this case includes a, quote, immediate payment amount. That's a JA 102. It doesn't say demand, but it demands payment of the immediate payment amount. It says that the fund is owed $1,577,000 and some dollars. At JA 102, it says its calculation of that liability is, in all caps, final. It says payments should be made to Matthew Tokarski, the fund's lawyer. It contains all these indicia of a demand for payment. We cite cases in our brief that say that a proof of claim is, quote, by definition, a demand for payment. And in this case, you don't even have to look at any of that, because in fact, the trustee took it as a demand for payment and
Where is the
paid.
default, though? And I'm sorry, I didn't mean to interrupt you, but I think you've already made the point about the trustee taking the payment. Where is the default that occurred? I mean, in order for you to prevail, there has to have been a default, November 10th, 2016?
So the proof of claim is filed November 10th, 2016.
Exactly.
It's undisputed that the bankruptcy filing creates sufficient doubt that, so the bankruptcy filing itself is the default. It entitles in this case, the bankruptcy filing occurred after the withdrawal. I don't have the date of our withdrawal from the fund off the top of my head,
Okay.
but it's undisputed that the bankruptcy filing here occurred after the withdrawal. And so after we've withdrawn and then filed for bankruptcy, it's undisputed that the fund was entitled to accelerate the
Right,
payment
but what's
obligation at
the
that
de-
point.
What's the default date?
The-
What is the default date based on your position?
I don't have the precise date off the top of my head. It's undisputed that it was before the proof of claim was filed. I should be able to get it for
Okay,
you
and
when I
what
stand back up.
constituted the default? Explain that for us.
So the bankruptcy filing itself constitutes the default.
You're
The
saying the Chapter 11 constitutes a default.
Chapter 11 or Chapter 7 constitutes a default. It creates sufficient doubt that the obligation will be fully paid
Well,
to
the whole
entitle.
purpose- But the purpose of 7 is so different from 11.
Right.
And it seems to me that it's more logical, if you're going to argue a default occurred, to say that it occurred when the 11 proceeding transformed into a Chapter 7, and you knew there was going to be liquidation, okay? But when the purpose of the bankruptcy proceeding in Chapter 11 is to reorganize and pay creditors, where is the default?
So it's very common in Chapter 11 also for creditors not to be paid 100 cents on the dollar. And so in light of that, we cite a regulation in our opening brief to the effect that of any bankruptcy filing, it creates sufficient doubt to entitle a fund to accelerate the obligation. They haven't even said that they weren't entitled to accelerate the obligation. All they're saying.
You're pushing us in the direction of holding that every proof of claim in bankruptcy automatically sets a statute of limitations running. And I just wonder what the overall implications of that would be for the basic purpose of this multi-employer statute. The whole idea of the multi-employment statute, it's a remedial statute. And the statute is designed to protect beneficiaries here. And it seemed to me what you were trying to do was to get out of paying your fair share and becoming a free rider and getting out and, not having to pay, taking all of the advantages of the multi-employment plan and then and then becoming a free rider and saying, I have no liability. I don't have to pay 1 cent. And you leave everybody else holding the bag. And that is not in what Congress, I cannot believe that is what Congress intended with a remedial statute, which, the very nature of which, in a multi-employment situation, the presupposition to that is that every employer pay a fair share, and you're trying to get out of paying your fair share, and I don't like it.
So respectfully, Your Honor, with my 2 minutes, I don't think I can take on all of what you just said, but here's what I'll take on. Congress enacted a 6-year statute of limitations. I think it must be common ground that that 6-year statute of limitations was not, in fact, designed to say that funds can bring their claims forever,
Fair
right?
enough. I want to interject so that
I
the
wanna
point
make-
that Judge Wilkerson is making ties in with my threshold concerns when I asked you about arbitration, which is required under the act. You said statute of limitations is something for the district court to discern. That is true, but the predicate issue, or whether that's a notice, is an arbitrable issue. That's the problem. You never asked for arbitration.
Well, so thank you, Your Honor. I did want to return to this conversation. I'm glad you're giving me the opportunity.
No, you don't have to return to it. I'm just telling you that plays in terms of the notice that's necessary here. The courts have said all over the country that issues of arbitration in these types of cases, when you're dealing with withdrawal liability, go to arbitration. And they include not just the substantive, but the procedural parts of it. Now, if we have statute of limitations of being something you can decide in district court, at least the predicate determination of whether that was noticed is an arbitrable issue.
So-
And you never asked for arbitration.
So, Your Honor, I agree we never asked for arbitration, and if I can explain why I think the premise of your question is in fact incorrect. When an employer receives a notice,
Give
if
me
they
one
want,
case that goes in your direction on that.
Your Honor, it's undisputed that the Seventh
No, I
Circuit's
want to hear
case
the
in
case.
basic,
When
in
you come
basic
back,
American.
when you come back, tell
I've
me
got
the
it for you
cases.
now, Your Honor.
When you come back, tell me the cases that support your position that that is not arbitrable, the question of whether this was noticed, and if you fail to get it up, you get arbitration, you can get a district court to do it.
Okay. Your Honor, may I eat into my rebuttal time for 2 minutes, please? I've reserved 5 minutes. I'd like to take 2 right now, if that's all right.
You've got some rebuttal time, and unless my colleagues have further questions of you, I'll ask you to save your time for rebuttal.
Okay, thank you, Your Honor.
Okay. Let's hear from the other side here.
Good morning. May it please the court. Brian Pepicelli for the fund and its fiduciary. We all agree that this case involves a single issue of whether the fund timely filed its complaint within the 6-year statute of limitations period. And we also agree that that threshold issue, that only issue in this case, turns on 2 predicate disputes under section 1399 regarding whether the contingent proof of claim was a notice and demand, and if so, whether it was an acceleration. And so Judge Gallagher.
Can you bring that microphone close to you and speak up?
Sure.
And if we determine the first issue, we don't need to get to the second one.
That's correct. So in order for the control
But
group,
address my predicate, at least the question I brought initially. And that is the question of what is the role of arbitration here? The act does require that arbitration is the means by which you settle this. Congress wanted that to happen. It didn't want it to be piecemeal the whole bit. The question of whether statute of limitations should be something that's arbitration is, I mean, you could go either way. Maybe the ultimate question, whether it's statute of limitation, maybe district court, but at least in my view, the predicate determination of whether it is a notice or not is an arbitration issue. And if it is, the failure to ask for it is fatal in this case. Is that fair, or if from your perspective, does that seem to resonate with you?
that's our entire case. Well, not our entire case, but on the first issue.
But it would be because if your answer is yes, that's the end of this case. We don't get into acceleration, we don't get into all the other questions. It really is purely just a question of is this a matter that should have been decided in arbitration, and the failure to ask for arbitration is fatal.
Absolutely. And so the Steelworkers Pension Trust case versus Renko, the 2017 decision, is non-precedential from the Third Circuit, but it addressed a very similar issue, which was whether a bankruptcy proof of claim was a notice and demand under section 1399.
Do you have, but aren't there cases going both ways on the question of whether, I mean, I take my good colleague's point, but aren't there cases going both ways on the overall question of whether a notice is a statute of limitations and notice under that is an arbitrable issue? I mean, there are cases going both ways on whether that's arbitrable, are there not?
I am not aware of any case expressly holding that a predicate dispute under 1399 regarding the notice issue or acceleration issue is not subject to arbitration. In the first instance, I'm not aware of any case to that effect.
Because if the suit is not time barred, either because they have to prove both that it was a demand and that it was an acceleration, right?
Correct.
Okay, if either one of those is not proven, then the suit would not be time barred, is that correct?
That's right. Even if this was a notice and demand.
And so what I think we're getting at is that there's several ways to wrap up this case. And one is by the arbitration issue, which my good colleague has suggested, but another is to find that there was either no demand or there was no acceleration. And if either one of those is the case, then the suit is not time barred. And so that wraps it up. We don't, we wouldn't have to say that it is or it isn't arbitrable. It could well be arbitrable. But I don't know. It seems to me that the overarching issue here is whether somebody's gonna be whether a company is gonna be a free rider and fail to pay its fair share and leave others holding the bag. And to me, that just guts the whole purpose of what this statute and what Congress wanted this statute to accomplish. And that is, you get the benefits of the multi-employer plan, and in return for those, you've got to pay your fair share. That's the point. You can't just skip out of town.
Agreed, and in BES Services, the 2006 decision from this court, it goes through and explains why the arbitration requirement is such a critical part of MEPA's overall statutory scheme. So enforcing this arbitration mandate and requiring that, as the text states, any dispute concerning the determination under 1381 through 1399 shall be resolved through arbitration, that's the end of the case, because arbitration is a very important part of the scheme. And it does not allow a group of control group defendants who have assets to pay this underfunding a way to get out of it. And this court's decisions in McDonald and Teamsters 83, they have been cited by district courts in the Northern District of Illinois and bankruptcy court for the proposition that this control group framework,
You've got a First Circuit case and a Third Circuit case, both of which indicate, I think, that the statute of limitations, both notice and acceleration and all of those which are statute of limitations issues, that those basic questions are arbitrable.
the predicate
And
disputes.
if they never ask for arbitration, then that's over.
Correct.
So
And-
you can, I don't know, it seems to me that all roads lead to Rome on this, in this question. I can go say, well, there's no statute of limitations issue because there was no operable demand or there's no operable acceleration. You can go with the First and Third Circuits and say that the notice and the question of demand and acceleration, which are bound up with the notice question, you can say that those were to be arbitrable, and then there's a waiver of the arbitration because it wasn't, they didn't ask for arbitration. My point is that it all goes to the same place. How you get there may be said, but no matter how you get there, you end up with the point that you've got to pay, every employer has to pay its fair share. That's where you end up. But you can go there through the waiver of arbitration, or you can go there by saying it's not time barred because there was no demand, there was no acceleration.
Sure, and so just one thing that I would point out is the Third Circuit's decision in Kiro Leasing, that is referred to by my friends on the other side as trucking employees. But in that case, the site is 377 F3D 288. And there, the control group defendant cited it for a different proposition, but the court specifically refuses to consider predicate disputes that would have to be resolved through arbitration under the MEPA. And then it even says, including its statute of limitations provision. So that decision is fully consistent with Judge Gallagher's underlying decision, which is, even if the statute of limitations defense is not in and of itself subject to arbitration, it can't be based on predicate disputes that are subject to arbitration, because that would be an end run around the statutory scheme that Congress enacted. But then even turning to the merits of it, we agree that this case should just be resolved on the arbitration issue. You don't have to get into the other issues. But just looking at the face of the bankruptcy proof of claim, it did list the liability as contingent, which is inconsistent with the notion that that this was a demand, because clearly it's an indication that the fund's trustees had not yet determined that liability had been triggered. And then it attaches a 19-month installment plan option. It says choices for payment from, and it says either the immediate amount or 19 monthly installments. And then it has an explanation as to what the interest would be under that installment option. And so if you go back to the face of the proof of claim, I believe it's JA 100, question 7, how much is the claim? 1.577 million. But then it says, does it include interest? Yes. That interest is only available not for that 1.577 million amount, it's only available for the lump sum option. So this was not an acceleration of liability on its face. It is undisputed that the fund's trustees did not exercise the acceleration option, and the case could be resolved on that basis too, either because it's not a notice demand, and regardless, because it's not an acceleration.
Can you pursue both a claim under the bankruptcy proceeding and withdrawal liability?
I believe so, yes. So non-bankrupt members of an employer's control group.
In other words, it's not an election of remedies.
Well, and this is a contingent proof of claim also. So the reason the fund was paid on the contingent proof of claim is because nobody objected to it. So by operation of bankruptcy law, it was deemed allowed without any judicial determination on that. So Judge Gallagher disagreed with the notion that we were taking an inconsistent position that how can we make a claim for an amount and then accept the payment on it if it wasn't a demand? The payment was received because it was provided for by operation of bankruptcy law, not ERISA or MEPA, the MPPAA.
Well, how do you explain away, though, your acceptance of that money in terms of the ERISA framework?
Well, it just means that it would have to be credited towards the overall withdrawal liability that was later assessed in March of 2022. And we did credit that once we became aware that that payment was received based on this proof of claim. We did credit that distribution towards the last payment in the installment plan. So it was accounted for, but this is joint and several liability. And as the court stated in McDonald, we can't let a group of control group defendants take money out of its front pockets and claim bankruptcy when it just moves it to its back pockets. These are independent obligations that this control group has to owe. And one of the things that, one of the first undisputed facts, which we dispute, was that they would have no reason to raise the statute of limitations issue during the arbitration period.
You just say undisputed facts that you dispute?
Yes, because it was, in the beginning of Mr. Siegel's argument, he said there's no dispute, but we do dispute the facts. So,
Well, let's say we have some of the questions at least have indicated that you can get to the preferred result of affirming the summary judgment by holding that this is an arbitrable issue and that the arbitration was waived because it was never requested. But you've devoted also extensive sections to your brief and saying, look, there's no demand here, there's no acceleration, the suit is not time-barred, and we should not be forced to litigate the withdrawal of liability claim, the withdrawal liability claim in a bankruptcy proceeding. We should be able to make a protective filing and protect our interest in that way. We should be able, if we wanted to accelerate, there should be some evidence that we were following our own rules in seeking an acceleration. So you got these several routes. Which I'm just asking, which do you prefer? What are the implications for pension funds of going the arbitrable route or saying it's not time barred because there was no demand or there was no acceleration. What are the different implications for the viability of the pension fund in choosing one route or another? Because the way I come in this, as I've said ad nauseum, that I want everybody in these multi-employer plans not to slip out of something. So from the standpoint of that value in upholding the remedial nature of this statute, which is the fact that there was no demand or no acceleration, or that there was a waiver of arbitration? What are the impacts of those different routes upon pension funds and preventing this free rider situation?
Well, I agree that this court could resolve it on any way, but if we just take them one at a time.
I'm asking you, what are the
Sure,
implications
sure.
for the pension funds and the viability of pension funds going one route as opposed to the other?
Okay, and let me add on to that. It seems to me that if the case were decided on failure to arbitrate, it's really kicking the can down the road on the main issue that funds would find very compelling, and that is, when does a filing in bankruptcy, does it operate as an acceleration? Does it operate as a demand? And if we say no, that it seems to me that is more significant in terms of the body of law
Sure.
than it is if you simply say you should have arbitrated and you didn't. But I don't know. Tell me if I'm wrong on that.
Well, I don't think that the court saying that this particular proof of claim was not a notice in demand would be a proclamation that no proofs of claim can ever be a notice in demand. The fund could have labeled this as a claim for withdrawal liability, and then in the attachments, put everybody on notice that.
But
we
are you saying to us that this is all fact-specific, that there can be plenty of proofs of claims that would operate as an acceleration, or that they would operate as a demand? There would be those instances, would it not, if there was if you were sufficiently insistent and you had a schedule of payments and you wanted to pay up? I mean, it would be at your option.
Sure.
It would be at your option as to whether you really wanted a proof of claim to operate as an acceleration or a demand. You would have the choice, but all you're saying is, we don't want to be in the situation where there's a per se rule that any filing of a proof of claim sets the statute running. And so I
Correct.
would think what you wanted to do from the standpoint of the pension fund is to avoid being put in that corner where every time you sought to protect your interests, you were setting the statute of limitations going. You want the option, do you not, of being able to decide whether you want to frame a proof of claim as a demand, or whether you want to frame an acceleration or an acceleration. You want that option, do you not?
Absolutely. We are not arguing that these bankruptcy filings could never satisfy the provisions of MEPA. We're just saying that they do not in this case.
Right, but you'd still have to meet, wouldn't you have to have an acceleration and a default in order for that to be the case?
Yes, the fund would have to expressly exercise the option and put them on fair notice that this full amount of withdrawal liability is now due all at once, which is contrary to the baseline obligation under the statute. But as far as enforcing this the mandate to arbitrate first, it would be a weird situation to say that all of these other disputes are subject to arbitration, but then they could hold back a predicate notice issue that they easily could have raised during either of the relevant periods in response to the 2016 proof of claim or the 2022 demand. But they did not raise those, and it was only after they were sued in this case and waived all other defenses did they start raising those. They do dispute having any liability to the fund at all, and they dispute the amount of the liability. They made that clear in the district court proceedings, and they made that clear in the Florida lawsuit that they filed for abusive process against the fund and myself. So to say that they had nothing to arbitrate back in 2016, if this was an accelerated demand for withdrawal liability, when they dispute the fact of the liability, the amount of the liability, and also it might not have even been proper for the fund to accelerate in this case because the statute says a substantial likelihood that the employer cannot pay. Employer here is more than Florida Glass. The fact that Florida Glass is in bankruptcy, that's not necessarily a basis to accelerate when it has other control group members that can pay the liability. And so if they can pay the liability, then they can make the payments on the ordinary schedule. This court's decision in Teamsters 83 involved that situation. It was an interim payments collection action against a group of control group companies when the contributing employer was in Chapter 11 bankruptcy. It was not an acceleration automatically or expressly because nobody exercised the option.
All right. Judge, do you have any? Oh, we have no further questions, thank you.
Thank you very much.
And you have some rebuttal time, sir.
Thank you, Your Honor. Just a couple of quick cleanup items that I promised last time I was standing up. At JA 44, the date of the Chapter 11 bankruptcy was August 9th, 2016. Mr. Pepicelli just disputed whether that Chapter 11 bankruptcy filing was in fact a default that would have entitled his client to accelerate, but there's no such dispute in the briefing, and at brief 7, we cited a regulation to the effect that a bankruptcy filing is a default, and again, that was just not disputed in the briefs. I'd like to return to the colloquy that I was having with Judge Wynn just before I sat down. And I really think this is important to my client's position and to a correct understanding of how the statute of limitations operates. So I want to make sure I can get it out if possible. So when an employer receives a notice, demand, and or acceleration, it's irrelevant to this conversation, this specific conversation, whether there's an acceleration also, there may be nothing to object to in that notice and demand. It may perfectly calculate the liability. It may contain all the attributes that a notice and demand is supposed to have in it. So there would be no reason to initiate an arbitration within the few-month arbitration deadline in that circumstance. And Mr. Pepicelli's position is that if we don't initiate that arbitration, that we would have no reason to initiate. His client can sue us 1,000 years later because we didn't initiate the arbitration within the 3 months. And so naturally, the statute of limitations cannot depend on whether an arbitration was initiated early on because you don't have notice of the actual problem that the statute of limitations is pointing out, which is not a problem in the notice. It's a problem in the lawsuit that could come 6 years and 1 day later, or it could come, 2,000 years later.
There's also a problem when withdrawal liability will occur. It doesn't just occur when you stop contributing to the fund. You must also be engaging in some type of contributory or covered work. And to know you are within the next 5 years, so it's a substantial period of time in between there in which the liability itself could arise, but it didn't arise just by not paying it. But when you file a bankruptcy action, and as I recall, it wasn't really a direct statement saying we are entitled to withdrawal liability. It was a statement of possibly this could happen. So it's a contingent situation, and the bankruptcy world is different than the pension world. Congress had a different place in mind when it enacted this Pension Act, and it had a lot of safeguards in it. It did something unusual. It actually took it away from the courts and put it with arbitrators, and it did it for a reason. One, it wanted to go quickly. One, it wanted to make sure things are tighter in the whole bit. So it's there. And as Judge Wilkerson alluded to, there are 2 circuits I know of, and maybe there are others that decided it differently, that issues dealing with arbitration in this vein, withdrawal liability under the Pension Act, are uniquely within the arbitrator's vein, and the arbitrator gets to decide those things, not the district courts. So that's the point. And it's not just the question of arbitration, it's the predicate determination of whether this was a notice is an arbitrable issue. You didn't ask for it Not even now. I mean, and even after it became aware that you could, you didn't do it within the 60-day period of time.
So, Your Honor, we're not challenging whether it's a notice. If an employer wants to challenge whether it's a notice, then it's got to go to arbitration. We're saying it was a notice. There's nothing to arbitrate. It was a notice. We wouldn't go to the arbitrator and say, hey, you just noticed, the fund just noticed a debt that we in fact owe. But what the statute of limitations says is when they notice that debt, that starts a 6-year clock. And we have nothing to challenge during the few-month window.
But there is no debt if you are not also engaging in covered work. And that was not known at the time.
That would be something that an employer could raise in an arbitration.
That would be something an arbitrator would determine.
Sure, but
for
this,
purposes of determining whether there was notice. But a district court can't, and you didn't ask for arbitration. Because you don't have a debt by simply filing the claim saying possibly it's going to happen, and all you've done under the withdrawal liability is stop paying. You stop paying, and then once you stop paying, that's not enough. You then have to be engaged in covered work over the next 5 years. Once that happens, then you have a potential claim for, a real claim perhaps for liability at the point.
Your Honor, my time has expired. May I answer? Or?
Just to follow very briefly on what Judge Wynn says, you say, well, there's nothing to arbitrate, but anytime you raise a statute of limitations defense, there would be something to arbitrate, because the statute of limitations, if you raise it as an affirmative defense, that would automatically bring into contention the question of whether something was a demand and whether something was an acceleration, and all the questions of notice that are attendant to that. So, I mean, the idea that, well, there's nothing to arbitrate, but there would be something to arbitrate at any point in time that you raised a statute of limitations defense.
Well, this is exactly my point, I think, Your Honor, is that we can't know that we're going to raise a statute of limitations defense until we are sued outside the statute of limitations, which is a 6-year statute of limitations. And that's years beyond the deadline to arbitrate. So Congress could not possibly have contemplated that those statute of limitations issues would be submitted to arbitration.
Every statute of limitations defense is raised generally because the defendant feels that it's way beyond the limitations period. And that's endemic to any statute of limitations defense. It's because you feel that this is a time-barred suit.
Right.
And so the minute you raise that, it becomes a question of whether it puts into play the whole question of notice and whether that's an arbitrable issue.
Well, it does put into play the question of notice, Your Honor, but to hold that we had to have arbitrated that issue within months of receiving the document that we say is notice would effectively eliminate the statute of limitations in the MPPAA, because we would be raising.
There's no reason that can't be arbitrable. All I'm saying is there are a whole lot of hurdles that you have to jump on this, a whole lot of them, including the basic question of whether every proof of claim in a bankruptcy proceeding is ipso facto something that a demand or an acceleration that sets a statute running. And so, at any rate, it's time for me to be quiet and to turn it over to my good colleagues, and if you have any.
If I could just add one point, there was a point I forgot to mention to Judge Wynn. Okay.
Your time has expired.
Thank you, Your Honor.
You've made many, many different points, and we appreciate that very much. But it's time to come down, and thank you for your good arguments and proceeding to our next case.
Thank you.
Come on up. We're, pleased to hear in Richardson versus Prince George's County. And that's our second case, Mr. Hallett. Whichever one, we're happy to hear from you.
Good morning, Your Honors, and may it please the Court. My name is Jordan Hallett, and I have the distinct pleasure of representing plaintiff appellant Randy Richardson, who's a small business owner that was denied the opportunity to participate in Prince George's County permitting process on an equal footing with large politically connected businesses. We argued in our brief that the district court erred when it granted appellee's motion for judgment on the pleadings, holding that the appellant civil rights claims were, quote, too speculative for Article 3 purposes, standing purposes.
Okay, Mr. Hollard, if I could just jump in with an organizational question. As I understand it, your argument is solely on appeal and equal protection argument, and that you're not raising the due process, you're not raising the negligence that appeared earlier.
Correct, Your Honor.
Okay, thank you.
Thank you. The district court's ruling was wrong for two independent reasons. First, requiring Mr. Richardson to have applied for and been denied a permit runs afoul of the well-established standing doctrine for equal protection claims. The Supreme Court has been clear on this point. When challenging a discriminatory barrier, the injury is the denial of equal treatment, not the ultimate inability to obtain the benefit. Second,
So to get this Article 3 standing on equal protection, what do you maintain is the injury in fact?
it's the erection of the barrier, the preclusion, Your Honor, of even being able to move forward in the permitting process on an equal standing from similar situated tenants at the same mall, at the same time.
So it's
The
not just a denial of the permitting process, it is the discriminatory barrier that you maintain is the basis for it.
Correct, Your Honor. And the Supreme Court has, over a number of years, has tried to make this point clear with respect to equal protection claims only. Because in other contexts, it would be, right? When you're outside the equal protection context, you don't have the same question about this erection of a barrier that would deny an equal opportunity for someone to participate in a process.
So then that brings the question, then is it a right claim if you didn't actually submit the permit?
That goes,
application?
Your Honor, that goes to my next dovetail point on this. We argue that it is right, and specifically under the futility exception that exists here for rightness. This court has not fully developed it with respect to, as related to other sister courts, as we allege in our brief, but in this court's Hamilton decision back in 2017, it adopted the futility exception that the sister circuits, some of the sister circuits have adopted, and that is if the plaintiff has made a substantial showing, right, a substantial showing, that applying for the benefit would have been futile, then they do not need to.
On the futile, the question is, are you getting to the point where you can just sort of bypass the entire permitting process on the grounds that the whole permitting process is a sham and that requiring us to go through it is futile. In other words, this is seems the question I have with respect to the argument you raised is whether it isn't very broad and giving a sort of a free pass to anyone who doesn't want to be bothered with the permitting process. It seems to me it comes the futility argument as you framed it comes pretty close to gutting the permitting process.
And Your Honor, I agree to a point. I will say it's a narrow exception. It is applied narrowly. And so in the context, on this case, judgment on the pleadings, we're just looking at the pleadings. And for the futility exception to come in play, the plaintiff has to allege sufficient facts to meet this substantial showing that applying for this benefit would have been futile. because the Supreme Court has made clear, and this court in 2017 made clear, that plaintiffs or individuals do not have to submit to, do not have to apply, do not have to submit to.
Well, I mean, I take your point, that, that it may not, the rightness claim may not be wrapped up simply because you can't say that something is not right simply automatically because they haven't applied, or they haven't been denied a permit. That seems to me relevant, that you never applied. And it seems to me relevant that you were never denied a permit. Not dispositive, and I get you on that point, that they were talking about equal access. But it doesn't weigh in your favor that you never applied, and that you never were denied the permit. So then the question becomes, what's the why is this futile? And on page 102 of the joint appendix, I think it's the district court's opinion where they talk about a letter from the director of the Department of Permitting that asked, and I said this was not just us, but a number of officials had asked to meet with the plaintiff and talk about solutions to this quandary. And they invite the plaintiff here to all sorts of conversations with senior city officials. And that sounds to me, it doesn't suggest a discriminatory barrier, it suggests the contrary, which is that the officials here are open to discussions on the matter and want to engage in a collaborative process to iron out whatever difficulties are involved. And how do you get around the fact that these invitations to meet with us, come on, let's talk about it, let's collaborate. And you say, oh, well, it would be futile to talk to you. And that's awkward for me.
I completely agree, Your Honor, and I wholeheartedly agree, because that invitation by officials does undercut on its face the futility argument. But as the complaint alleges, and I'll get to this in a minute too, but as the complaint alleges, the ultimate meeting with the then director of Department of Permitting Inspectors and Enforcement was canceled. And then the appellant here, Mr. Richardson, tried continuously to meet with the director afterwards and was not permitted to do so. With the other county officials, all of that was not let's get a permit, let's figure out how to get you out and how we were gonna make this right, because things are not going to move forward here, because the mall doesn't have a use and occupancy permit, and we're not going to actually be able to move forward. So let's figure out an alternative.
I admit that bureaucracy can be frustrating. I mean, we've all in our lives, every person in this room has had to deal with a bureaucracy at one point or another, and you get a lot of the runarounds, and you get all sorts of shell games and everything, and it can be infuriating. But the question is here, in light of equal protection law, how are the innate frustrations of any permitting process related to race? And that's what I don't understand. Why would they not be related to traffic congestion, or to the size of the business, or to the kind of commercial mix that the owners of the shopping center wanted to have for the shopping center as a whole? I mean, I can think of 1,000 different reasons why it isn't related to race at all, but just a general frustration with every permitting process. I don't know of any permitting process that just, goes so smoothly.
Yeah.
Your Honor,
Could I ask, when you answered Judge Wilkinson, could you clarify also, would be helpful? As I understand it, you're not just arguing race, you're talking about big guys versus little guys, people being treated differently based on the Chipotles and the Shoppers Worlds were moving in, and Mr. Richardson was moving nowhere. And so how much of your equal protection is based on the race issue, and how much is it based on the big guy, little guy?
Yes, absolutely, and Your Honor, I'll start with Judge Wilkinson's, and I'll dovetail my answer, response to your question into that. Your Honor, I completely wholeheartedly agree as someone who has a million cases against the same Department of Permitting, Inspections, and Enforcement Agency. If any of those reasons that Your Honor just stated was the basis here, we would not be here. But those weren't the basis that were provided to our client. And in fact, the agency told our client one thing, right? You can't get a permit because the mall doesn't have a permit. So it doesn't matter what you do, you can't get it until the mall figures it out. Now, we found out in discovery, although we weren't able to present this, and that's my next point with the 12C motion.
Let me get back to Judge Keenan's good question, and that is this a racial claim, or is this a big guy versus little guy claim?
So initially, right, as a result of discovery, it is predominantly a big guy versus little guy, a class of one equal protection claim. That's what we spent 6 months in discovery finding out, that this is a difference of treatment between the same tenants in the same space. If you're a big box store, you got a different level of treatment, even though the mall didn't have a use and occupancy
All right,
permit.
but then we are back to rational basis equal
Correct.
protection. Well, how many times do we overturn a claim on the basis of an irrational basis? I mean, it seems to me you might have been in a stronger position if you say this is a racial claim, because then you're in some kind of strict scrutiny. But when you say, no, this may be a big guy, little guy, first of all, that suggests to me we're back into rational basis. And second of all, this Willowbrook class of one business, it's almost never invoked. It is, they did it one case, and then they have retreated from it. And it is not a staple of Supreme Court jurisprudence. And that is because anybody at any time can, hey, I was denied this, I'm a class of one just because I'm me. And I think that's, if this is not a racial claim, then you run into some real problems.
And Your Honor, I take your point, and you're absolutely correct. It is very difficult to win on a rational basis, class of one. I mean, it has to be arbitrary and capricious in the terms of how the agency is treating one individual. It is a predominant big and little guy, but we have, and in discovery, we have determined that only the African Americans and minorities were treated differently in the permitting process. They're the only ones who were denied, and we have,
So it's a racial claim. Which is it?
Your Honor, my point is that it's both. It's just and it can be both. It's just that we have developed in discovery that it is clear that if you were a large business, that you were receiving preferential treatment. Now, it just so happened that.
So what? I mean, there are many shopping centers that want big anchor stores.
But Your Honor, erecting.
That's what brings in the business.
No, and I understand that, Your
So
Honor.
the smaller stores, the big stores, the anchor stores, bring in the business for the smaller concern.
Your Honor, absolutely. And if that was the reason, but that's not what DPI, that's not what the Department of Permanent Inspections and Enforcement did. What they did was said, you will not be able to get a use and occupancy permit, minority small business owner. You will not be able to get one because the mall has all of these issues. Now, the interesting thing here, as alleged in the complaint, Mr. Richardson's store was right below Shoppers World in the same building. And Shoppers World was given the opportunity to operate lawfully and open a business at the same time that Mr. Richardson was saying, wait, you told me that we wouldn't be able to operate because the mall doesn't have a use and occupancy. I'm sorry, Your Honors, my time has expired.
Well, let me just ask you one quick question. You were talking about Shoppers. Shoppers was using the same sprinkler system, right?
Yes,
Okay,
Honor.
and Richardson was being fined, what was it, in March? No, in February 26th, he failed the inspection, including the sprinkler system, yet Shoppers moved in 1 month later using the same sprinkler system. How does that focus in?
Your Honor, that just shows that the difference of treatment being applied to Mr. Richardson here. It was very clear that the county, the mall owners wanted him to open. They tried everything. They tried working with the county. That the county did not want him to open his business, and they used the excuse that the mall didn't have a use and occupancy permit for him specifically and the other minority owners that we deposed in this case over 6 months of discovery, that they did not want those businesses to open.
Okay, so we're gonna be in a situation now where every shopping center around, all through the circuit, that every decision with respect to occupancy or to which stores allowed to open and which stores aren't, are now gonna be brought up to the Fourth Circuit under a class of one rational basis. Saying, what, are we becoming mall operators? I'm more open to a claim of racial discrimination, but the idea that we're talking about size or a commercial mix or something, that seems to me to get very, very difficult.
And Your Honor, this court can absolutely reverse the district court on the equal protection on race. It is alleged sufficiently in the complaint, because again, the problem here is the 12C motion was decided well after discovery. So now we're just focused on the complaint. But we developed a strong factual record, and the entire, one of the biggest issues in this, and it's our second argument here, is that for the 12C motion for judgment on the pleadings, the court ruled on it after discovery, after the parties engaged in extensive discovery, including 8 depositions, 2 entity depositions, all sorts of written discovery, and did not give the appellant, the plaintiff here, an opportunity to even have a hearing to present what sort of evidence may have existed to fill in the gaps, if there were any perceived gaps in the complaint, which is...
Your suit was dismissed without prejudice. You can go back and take them up on their invitation and the rest. I mean, if you're not out of court, it was dismissed without prejudice, you can give it another run up of the flag.
Your Honor, and I understand that. The only issue with, the issue with that is the case, so much resource and discovery was done at the end of the day. And all we wanted was a hearing to be able to inform the court what information was gathered in discovery to fill in any perceived gaps that the court may have thought for Article III standing purposes in particular, and then the futility.
Okay.
I'm
All right, let's, wait a minute. All right, thank you.
Thank you, Your Honors.
All right, sir, we're happy to hear your side of it.
Thank you. Good morning, Your Honors. May it please the court, Roger Thomas, arguing on behalf of Prince George's County, Maryland. I do want to start the presentation by addressing the issue of alleged failure to allow discovery in this case. So the lower court decided, made the decision on the motion for judgment under a Rule 12C. That allows the court to make a ruling on the motion based upon the allegations set forth in the complaint itself. In this case, the allegations, the factual allegations are largely undisputed. We know that the appellant, Mr. Richardson, he never filed and never submitted the use and occupancy permit, which is largely at issue here. We also know that there was never any denial of a use and occupancy permit by the county.
But it's not as naked as you're presenting it, that they simply didn't ask for a use and occupancy position. they were told multiple times, you can't get one because that mall is not eligible for it, multiple times. And ultimately, you even had someone who was pretty high up to say, yeah, you've been harassed, and that's what's happening here. It's one thing to say you didn't get it, but there are a lot more. There's a lot more packaged in this case, some of which is very odd as to what's going on in this case and why this is happening here. Even with the procedural posture of a 12C, typically before discovery, but you actually have discovery, and the judge then makes a 12C determination after discovery. It's kind of odd, but just to be clear, your statement is simply he didn't ask for one. There's a lot more to that than he didn't ask for a permit. In the face of all that was going on, it's pretty egregious in terms of the factual determination of not asking for one.
So, Your Honor, it's certainly, there's certainly more in this case than he simply did not submit or request the use and occupancy
Didn't
permit.
seem like it was any use for him to do so. If you've been told by the very people who make the determination you're not gonna get one, why would you?
And he kept getting fined one time after another. This is what bothers me about the case.
Right.
That he kept getting fined. At the same time, he was told that it was above their pay grade to deal with this, that there were, or that he didn't qualify. He was getting all sorts of explanations and then ends up with $9,500 worth of fines after being told that the Iverson Mall issue had to be resolved. And yet the bigger tenants were moved in. He was clearly treated differently, it seems to me. The question is why? And has he alleged enough?
Right. So in this case, it's the county's position that clearly he has not alleged enough. There were ongoing discussions between the appellant, officials from the county executive office, officials from DPEI, and officials from the county council. It's undisputed, and it's alleged in the plaintiff's complaint that he was told that they were looking for long-term resolution of the issues impeding the permitting process.
But you got a small business, and small business owners have a difficulty in a circumstance here, and even though the focus may not be on the size of the others, but you certainly had other businesses that were being allowed to be there. In the face of repeated indications you can't get one, then you get most unusual and actual admission. You are being harassed. You are being denied, whereas others are being there. And this is the county. And then in the midst of it, not that settlement makes a big difference, offers make a difference. There's something going on here that's pretty unusual for an official, elected officials whose duties are to help citizens and small businesses of all. I mean, it's one thing to be in a small business trying to get a foothold into a mall of this size and then denied repeatedly. Obviously, I do not know the reason. Maybe it could be for the discouraged. I do not understand the underlying reasons of why that all happened, but I just pointed out again to go back to say it's not just a black letter case where he didn't ask for it, so therefore that's the end of the case.
So, Your Honor, on the concept of quote unquote, he was denied repeatedly, the record does not support that type of determination. He was specifically told that he could not be issued the use and occupancy permit until the permitting issues associated with the mall itself were resolved.
Let me ask you this, with this, in light of the frustrations and what's going on here and the rest, why isn't this basically, if this is not a racial claim, why isn't this basically a matter of state law? There must be numerous causes of action that can be brought before the state courts on something that has to do with the utilization or the operation of a shopping mall, and it's there must be real property questions involved, and the like. If it's a racial question, then it seems to belong in federal court, but we're not having trouble figuring out exactly what it is. But all I'm suggesting is, I don't understand why the state courts, who have the same duty that Judge Wynn rightly alluded to, of making certain to, acting in the interest of their, of the public and of their citizens. But this feels to me, if it's not a racial case, if it's just a rational basis case, it feels to me much closer to land use and much closer to property law and much closer to perhaps contractual breaches or whatever. But it sort of walks and talks to me like a state law case if it's not a racial case. And which is it? Which is it?
And Your Honor, there very well may have been, basis upon which the appellant or the plaintiff in this case could have opted to file his cause of action in state court and try to invoke, some state regulatory statutes or state statutes that may have had an impact on this case.
But how could they? Because at least, and I'm speaking from Virginia because all my zoning experience as a lawyer came in Virginia, but you had to have a decision from which to appeal. Now, maybe Maryland's different. Maybe you can appeal. Are you saying Maryland is different, that you don't have to have a decision from which to appeal in the state system?
Your Honor, I believe that the point you are making is exactly the point that's really at the crux of this case, and that there was no final decision, by DPI.
Which is where the futility comes in.
Exactly.
But what I'm saying is to have a state law remedy, unless Maryland is different, and if it is, please tell me how. You have to have a decision from which you can appeal through the state administrative process.
And that is correct, Your Honor.
Okay.
And we don't have that in this case present before this court, and the same would have applied had he tried to file a lawsuit in state court. What we do know is counsel has raised the issue of futility. That doctrine just simply does not apply here. The futility doctrine does not apply where the party seeking the benefit, where it's simply a mere uncertainty or it may be something that's against the odds of succeeding. Here, in this case, I think one of the most relevant factual issues upon which the court based this decision is that there was ongoing discussion, trying to come up with the long-term solution about the permitting process. So there was no finality of any administrative decision, that would apply here. And that is largely the basis upon which the lower court, determined that this was not ripe and that there was not standing here for the case to move forward. The court properly decided the case based upon the allegations and the merits as pled in the complaint itself.
But the final decision can at some point a non-decision becomes a final decision. And at some point, the non-decision becomes a de facto denial. And that would, again, channel it toward a state court resolution.
And Your Honor, in this case, I have to respectfully disagree that there was a quote unquote non-decision. Had there been an actual submission or filing of the use and occupancy permit, and had there been an actual denial, then I think that you would have had a decision from which an appeal could be taken, whether it's.
But to be fair, again, you gotta look at the facts of this case and not selectively choose how you wanna look at it, but there's a letter coming from the director, and basically he is saying, let's look for long-term potential solutions. That's 14 months after he's asked for this lease. And all these things are going on. He's constantly trying to get this business. He's gone through the liquor type situation with it in terms of getting permits for that. He's looking for ways in which he can establish his facilities. He's leasing it. He's doing everything he can, but it's the government officials that are thwarting his efforts. And Judge Wilkinson rightly alludes to, why doesn't the state court deal with things like this? Well, perhaps if it was a building code or just the denial of permit is one thing. But this is where an allegation is made that you are selectively enforcing the law and you are discriminating against this particular individual here by a governmental agency. That's a federal question. That's where we come into play on it.
Right.
But to say that it was not a denial because, they just say, well, we're just looking at it, is a lot more in the record than that. Particularly when you get a letter from the director 14 months after he's released. In the meantime, regardless of whether or not it's a major national corporation or some others, you're having other businesses come in. And apparently this is being offered, but not to this small business owner.
Your Honor, one of the things that I think is important in the record and I want to bring to the court's attention is the county was actively working with Mr. Richardson to resolve issues of the permitting process. That included when he did actually apply for permits to begin construction on certain portions of the property at issue. That process did work its way through. He was granted those permits. So,
Well, counsel, what my dear friend Judge Wynn has just expressed has no limiting principle. If we're going to look at at every individual who is frustrated in trying to receive a permit with regard to a shopping mall or with regard to a permit of any kind and encounters frustrations, you can all build a record of that. And we're going to say, hey, you've made a federal case of it. Well, you might be able to make a federal case of it if there's racial prejudice afoot. That's one thing. But to just say, chalk it up to general frustration, there is no limiting principle to that. And we are not shopping mall owners, and we are not simply directors of permitting or whatever we're supposed to do to straighten all of this kind of thing out with the very tangled record and the rest. The state courts have a role in this and exactly this kind of dispute, if indeed it's not about race. If it's about race and the McDonnell-Douglas proof scheme is set into motion properly, then that's a different question for me. But there's no limiting principle to the alternative, rational basis, class of one, that sort of stuff. See, they're different.
absolutely. And Your Honor, I think the point that the court makes
What are you saying absolutely to? What part of that are you saying absolutely?
meaning that,
I mean, can you articulate your point of view? I heard Judge Wilkerson, I don't hear you say what he just said.
Sure. I think what it comes down to here is, in this case, Mr. Richardson's assertion that he is somehow being denied equal protection of the law is purely speculative. The court would have to make certain findings and conclusions that are just not factually supported, by the record. Under a 12C analysis, what the court properly did is it reviewed the four corners of the complaint and the allegations that were specifically pled in the complaint and determined that, the matter was not ripe, that he lacked standing, to bring this action. And that finding was absolutely correct under the standard of review on a Rule 12C complaint. The court expressly stated that it would not become involved prematurely in quote-unquote abstract disagreements over administrative policies where a formal administrative decision has not been formalized. That simply never occurred in this case because there was never any final decision made on a UNO because the application had not been submitted, because the discussions between the county and Mr. Richardson were clearly ongoing. That is undisputed. And finally, there was never actually any denial of the use and occupancy permit.
Do you need a limiting principle if you have the facts of the case like this? Because everybody would go out and the small businesses would seek permits of all different types, and race is a major factor here, I understand that, but just think of it in terms of a small business. who's trying to establish in a particular mall, has particular benefits, a lot of economic benefit, and the county officials tells them, you say not repeatedly, but it's over that 14-month period before that letter comes in, and then he even get an admission, oh, you've been harassed in the whole bit that's there. We're on 12B6 here, and in the context of this, he's not able to establish his business, he's losing money the whole time, you others are getting it and he's not, and constantly over and over, this is not something that's allowed. This is not something at all. And the allegation being equal protection on discriminatory barrier, whether it's race or whether it's a political factor or whether it's some other type of factor that's involved in it, I don't know why you need a limiting principle when an individual has those kind of facts. Granted, if you just come in and say, I didn't get a permit because, they didn't like me or something like that, it's another thing, maybe. Or it's a building code violation of construction. But there are facts in here that make this particular matter somewhat different than the kinds of cases that would create the so-called floodgate of cases to us, from my perspective.
Right. And, Your Honor, I understand the perspective that Your Honor has on that issue. But here again, the lower court in this case correctly reviewed the factual allegations that were presented in the complaint itself and applied that factual framework to issues of futility that were argued by Mr. Richardson, to the issues of whether or not the allegations as they were presented were too speculative, for the plaintiff, for the appellant to move forward in his lawsuit. The court correctly—
Are you saying that the discussion here and the suppositions here have wandered a significant difference from a distance from the complaint?
Absolutely.
That's as we've been talking about the frustrations that have been experienced and the repeated denials and this and that and the question, but is all of that in the complaint, or is that just us talking about generally about small businesses and the woes that they may or may not be experiencing? But I mean, is all this in the complaint? Because that's what we're dealing here with, the dismissal without prejudice. And if there are all of these problems to which my good colleague alludes, then one would think an amended complaint, which is perfectly open, would resolve those. The appellant here has had the benefit of this argument. It knows what the concerns are, and then he can go back. It's been without prejudice, and we can't do the work for the appellant here that the appellant is supposed to do with an amended complaint. And that door is open to this individual. He can put in all kinds of factual material to which we have alluded, everything, and then the district court can look at that. But he's asking us to do the job that the plaintiff has to do with an amended pleading. That's where we're asked to go. And that's certain pieces in the adversary process have to work in the manner in which Congress and the federal rules intended.
And Your Honor, on that issue, my time has almost run out, but on that issue, certainly the county filed its motion for judgment under Rule 12C based upon the allegations of facts pled in that complaint. We know that there's nothing in the record to show that the appellant ever filed the amended complaint, which he certainly could have. And also this issue about the court not affording the opportunity for discovery. Discovery was not necessary based upon the factual allegations that were largely undisputed as pled in the complaint. The lower court simply determined, based upon those factual allegations, that the appellant had failed to demonstrate standing, nor that this case was right. And the court—
That's an excellent point. And the point is that this amended complaint could have been filed. It could have shored up all the obvious weaknesses of the case. It could have presented us with adequate allegations, but it was not. It was, the amended complaint was not filed. Oh, it would, you can't say that would have been futile because the futility doctrine does not apply to an amended complaint.
Definitely, I definitely agree with that assertion, Your Honor. The other thing that was certainly available, albeit I don't think the court was required to permit it, I mean, the plaintiff or the appellant could have, requested a stay on ruling pending the filing of an amended complaint or pending discovery, but that type of relief was not necessarily required because the court had before it the complaint that had been filed, the complaint that was at issue.
It's not our job to draft an amended complaint up here. That's not our job.
Yes.
All right, let me see if Judge Wynn, Judge Keenan?
No.
All right.
Your
Thank
Honor,
you.
we would just simply respectfully request this court uphold the decision and memorandum in order of the lower court. Thank you. And I thank you for
Counsel,
the
give us some
honor of
rebuttal
arguing
time.
before the court.
Good morning again, Your Honors. I just want to start, Judge Wilkinson's, with a comment that you made. Everything being discussed here today, everything that Judge Wynn has raised is in the factual record in the complaint. This discussion that we're having today would have been great to have with the district court with respect to, because the district court only ruled that on the Article 3 standing issue. It did not get into the merits of the equal protection argument. It did not get into any other situation, but everything we've discussed today is in the factual complaint. What the district court said was, you didn't apply for a permit. It was too speculative as to whether you would have obtained a permit, and so therefore, on standing principles, you can't bring this suit. That's what the district court said, and what we're arguing here today is that the facts as pled in the complaint are sufficient for Article 3 standing purpose. There's a live case in controversy here. There's an injury in fact, there's causation, and it can be redressed by the court.
I mean, that's just a bare bones recitation of the elements of standing, and I understand that, but, I mean, we've got to, by dint of our various questions and concerns, you've got a blueprint that you can go back with and take advantage of the opportunity that you have to file an amended complaint and shore up the problem.
Your Honor, if we would have, if by filing an amended complaint would have fixed the issues as alleged by the district court, we would have absolutely done so. The problem was there was no fixing the issues.
Yeah, but if it's futile to file an amended complaint, a district court would then deny leave to amend. And the district court would say, I'm going to deny leave to amend because the amendment, any amendment you made would be futile. But that's not what the district court said here. The district court did not deny leave to amend. The district court was dismissed without prejudice, which was to open the gates for an amended complaint. And if the district court found it would be futile, all he would have had to do was to deny leave to amend. But that's not what happened.
Yes, Your Honor, and I completely understand that, and I will just note that the district court order occurred after the close of discovery. Discovery was afforded, both parties were afforded an opportunity to do discovery for 6 months. There was no, the appellant takes the position that there's nothing factually that can be added to the amended complaint that would have satisfied the district court on its holding for Article 3 standing purposes only. If the district court had denied it for deficiencies with equal protection or anything else in the claims, absolutely. Absolutely, there would have been an opportunity, and we would have availed ourselves of the opportunity to file an amended complaint to affect those deficiencies. But there was nothing that could have been done with the complaint here because the district court made it clear that Mr. Richardson should have applied for the permit, And if he was denied after applying, then we have Article 3 standing. And what we're arguing here today is that is not required. That's simply not required under the Supreme Court's precedent with respect to equal protection claims. I'll also note that although the Fourth Circuit has not held this, the Second Circuit in Ideal Steel, which is cited in our brief at 652 F3D 310, Second Circuit 2011, that in that case, the Second Circuit held that the district court erred in dismissing a complaint under Rule 12C when evidence produced in discovery could fill the perceived gaps in the complaint. And then in the District of Maryland, back in 2011, in the Stevens v. Showalter case, the District Court of Maryland recognized in the same tune, quote, there is at least some authority for the proposition that Twombly and Iqbal do not require dismissal of a suit.
Well, one thing we might get straight, if there was an amended complaint, is what I'm confused about now, whether this is a racial equal protection claim, or whether it's a rational basis equal protection claim, or exactly what is it? And if there's no rational basis, then say there's no rational basis and explain exactly why. I mean, I'm speaking purely for myself, but I think that this case is not in an advantageous posture. It may be that the district court was wrong to say the fact that you haven't applied and the fact that this was never any denial, that doesn't seem to me to be conclusive with respect to the issue here, because you're right to point out that the court's decisions have talked about equality of access and opportunity, and so the district court was too quick, in my judgment, to say, oh, well, all I need to look at. But we can remand it and say, look, here's what needs to be done that isn't done in the posture. And I should stress, I'm talking only for myself. But this case could come up with us in a much more developed factual situation, and just to my way of thinking, and I have no problem with admitting that the district court was too quick on the trigger here and saying, well, I'm going to deny because you haven't applied and you haven't been formally denied. That's premature. We need to know more, is what I want. That's all I'm saying. It would help me a whole lot to know more, and you've been given a blueprint.
And Your Honor, I completely agree with you, which is why we argue that it would have been more proper for the district court to convert the 12C motion to one for summary judgment, since discovery had been completed, at which point both sides, and specifically the appellant here, could have produced all of the evidence that had been gathered in discovery to show that this is an equal protection claim based on two things: race and the small versus big businesses. We have gathered sufficient evidence to establish both, or at least to create a genuine issue of material fact on that, and we weren't given an opportunity to develop that record for Your Honors today. And we ask, I know my time is up, I apologize. I respectfully ask that this court reverse and remand the order of the district court on the facts specific to this case. Thank you.
We thank you very much. We'll come down, and do you want to take a recess? Or okay. You okay?
Would it be okay if we just took a couple minutes?
Absolutely.
Oh, thanks.
We'll come down and greet counsel and take a brief recess.
This honorable court will take a brief recess. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. All right. Mr. Hallett, what a pleasure. Good to see you.
Good morning again. May it please the court. My name is Jordan Howlett, and I have the privilege of representing plaintiff appellant Garnell Walls. Mr. Walls has owned a parcel of property in Brandywine, Maryland for over 40 years. He sought to build a single-family home on that property, nothing more. But the Prince George's County had rendered his property economically worthless by categorically refusing to grant him a waiver to install an interim well and septic system, despite the county's own 2018 water and sewer plan expressly providing for such waivers. This appeal presents two issues: whether the district court erred in dismissing Mr. Wall's Fifth Amendment takings claim for ripeness when the amended complaint plausibly alleged that DPI made a final decision regarding his waiver application, or alternatively, as we've discussed in the last one, that pursuing such an application would have been futile. Second, whether the district court erred in suggesting it would abstain under the Buford abstention doctrine, even if Mr. Wall's claims were right, despite the fact that Mr. Wall sought monetary damages under 42 U.S.C. section 1983. I respectfully submit that both of the district court's conclusions were error and should be reversed. The finality required, the ripeness argument. The Supreme Court has made clear that finality requirement for takings claims is, quote, relatively modest. That's from Pactel 594 U.S. at 478. All a plaintiff must show is that, quote, there is no question about how the regulations at issue apply to a particular land in question, end quote. Here, the amended complaint plausibly alleges that DPI reached precisely such a definitive position regarding Mr. Wall's property. Specifically, the amended complaint alleges that Mr. Wall submitted a completed waiver application to DPI. That's at Joint Appendix 62, paragraph 40, and that's Joint Appendix 115, Mr. Wall's declaration at paragraph 7. The amended complaint alleges that Department of Permitting Inspections and Enforcement expressly stated it would not approve the waiver. That's at Joint Appendix 62, paragraph 41, and Joint Appendix 115.
Your complaint incorporated the DPIE letter that expressly stated that it would necessitate pursuing the legislative amendment process, and you didn't. How does that make it? It seems to go against the whole notion of being final, notwithstanding, I guess in most instances, just to casually say it, but this letter said, if you want to pursue, you want to continue this, then here's the avenue, you do so. And
Yes.
you did not.
Yes, Your Honor, and we addressed that in particular in our reply brief. Specifically, that's a legislative process. That is not an executive process, an agency process. That's a whole entirely separate, distinct process. And there's no.
But these are done routinely, plan amendments. I mean, you're not talking about a rezoning. There's a big distinction between a rezoning and a plan amendment. And all he had to do was to go in and make a hardship showing and get a plan amendment. And why wasn't he required to do that? Again, it wasn't a legislative act of rezoning. It's simply a routine plan amendment, and they do those every month, don't they?
No, Your Honor.
Pretty frequently?
So before filing the.
I mean, I don't know how often they do, but as I understand it, those are routine.
The district council sits in Prince George County for landing and zone use.
Right.
As alleged in the amended complaint, the director of the sewer and water division at DPI informed Mr. Walls initially, it has changed as alleged in the amendment, but informed him initially that DPI would not support the legislative amendment
But it would
process.
have been so easy to resolve this problem. Why not just apply and then wait for a denial, and then at that point, we have a case of controversy. If there's a denial and it's a very clean case of controversy, or it may be that the court would grant the waiver, and then we have no controversy at all. And so, again, it would seem, and I think this is the drift of my fine colleague's question, that there were some relatively straightforward steps you could take that would either result in no controversy or a clean case of controversy. But right now, we're stuck in this never land about a case that seems not right. And you're seeking a waiver here, and normally waivers are a matter of grace. You would normally expect a developer to connect property to public sewer and water systems. That's the normal course. And what happens too often, and we've sat on a lot of these cases, and what happens too often is that developers are all too happy to get their permit and to throw up their development. And then once the revenue from the rent comes in, they don't want to pay for the public and sewer connections and hookups and the water hookups. And they're in there dragging their feet and fighting about it and everything. And so what Prince George has said is that, you know, we want to have some assurance that these developments that are going up are going to, they're going to have public sewer and water hookups. That's crucial. And the letter of February 28 said that the financial responsibility in the particular designated areas, 5 and 2, in your situation, the financial responsibility for the hookups belonged with the developers. And there's nothing wrong with that.
No, Your Honor, I completely agree. I think that's how it should be. The problem here, there was no developer, right? There was no developer that would have been able to do that as alleged in the amended complaint. There was a Saddle Creek, a community that was at the pre-planning phase called Saddle Creek. That's 6 to 8 years down the road from even breaking ground. And so there was nothing in the interim, and this is why the waiver is available for Category 3, 4, and 5, which the appellant is in Category 5. And it's literally on DPI's own waiver that if you're in Category 5, you can qualify for this if you meet these eligibility criteria. And we allege in the amended complaint that he met all of that. In fact, he went through and worked with a different person, different divisions at DPI to get to the very end of the process. At the very end of the process, where he's just submitting the application, he finds out that that's not going to be approved because...
Well, but you didn't submit it, did you?
No, we allege, no, Your Honor, this is different. This one's different from, we allege that he did submit it. He actually did submit it, and we allege in the complaint that he submitted the application. It's the appellee's argument that he did not submit it.
Well, the district court accepted the proposition that your representation that he submitted it for purposes of her decision, did she not?
Your Honor, I don't think the district court went that far. I think that I think what the district court said was that there weren't sufficient allegations. So in the original complaint, the district court said that we didn't specifically allege that the application had been submitted. So we amended the complaint, and not only did we amend the complaint, but then we had a declaration from the appellant confirming that he submitted the waiver application. What the district court said was that the district court said that that she did not find it sufficient based on the allegations alone and based on the declaration from the site and sewer water coordinator who said there was no application submitted, that there was that there was no application, that the
I
complaint
thought
didn't.
she said she didn't have to resolve that the problem was the failure to pursue other remedies.
No, that's the next part, Your Honor, of her decision,
I
because
thought that was the ultimate basis for the decision.
the ultimate, Your Honor, from what I can recall, is that it was a ripeness issue again, that there was no finality made by DPI because a waiver application, according to the court, had not been submitted and there was no decision made on the waiver application, so there was no finality. Even if there was, what the district court said is that the district court said that the case would still be dismissed under the Bureau.
Why should we be jumping into the middle of water and sewer hookups in every development in Prince George's County? You know, once again, I don't know whether there should be Burford abstention or not, but at any rate, it would seem to me that we shouldn't just go racing into a question of whether to grant a waiver or not to grant a waiver on water and sewer hookups. And the presumption would be that if you want a development, the developer pays for water and, or if you're gonna put up one of these, the developer pays for water and sewer connections.
Yes, Your Honor, and if there was, but there is no developer here. We have an individual who is 78 years old who wanted to build on property that he purchased 40 years ago as his retirement home, and he's being told he can either pay for it himself, $2-point-something million to make the connections, or he can wait 6 to 8 years for Saddle Creek Development to come in, at which point the developers would pay. Now, the problem
Or
is
he can pursue this amendment process.
and I'll go back to that, Your Honor, because
But before you do, even think about it, tell me about this category, because you mentioned the category 5. As I understood, the representative said they weren't gonna recategorize it from 6 or 5 or whatever. You couldn't get it there, but is it not true that you could get it with category 3 or 4?
so.
I mean, in other words, you could get the permit for the septic tank and maybe an interim septic tank and well with 3 and 4?
So to be clear, Your Honor, on that, Mr. Walls would have to pursue 2 legislative amendments to get down to 3, at which point, and they're not, unfortunately, if it was just a month, 2 months, or 3 months, that would have been something that he would have probably readily done here to try to resolve this. That's not how the process works with the
Okay,
district.
yeah, tell us a little bit about that process. How do you go about a plan amendment request?
There's a specific application. It's the legislative amendment process before the district council, and there's an application that you fill out. There's supporting materials, and at which point, at some point, the administrator will schedule it for, I think, a pre-hearing, then ultimately.
So you're saying there's a separate decision of the zoning administrator?
No, just for scheduling purposes, Your Honor, just for
Okay.
scheduling it before the district council. That process, at least back in 2022 and 2023, and it might have been because of some fallout because of COVID, that process was taking more than a year to do, just one legislative amendment.
But ordinarily, it doesn't take that long, does it?
I'm not, you know what, Your Honor, I would,
You don't know?
I don't know, but I would assume that maybe pre-COVID, maybe it wasn't that long, but I'm not 100% sure in Prince George's County.
When did you get the letter suggesting you do that? What date was that? This year?
February of 2022, Your Honor, was
So
the,
this is 2025, 3 years later.
yes,
I mean, you'd rather go this route and wait 3 years than maybe a year to see what goes on there? I mean, if I understand it correctly, you still can do this, right?
what's that, Your Honor?
You still can seek this amendment process.
You can, Your Honor.
I'm
you
assuming your
can.
client has not yet
He
been
hasn't-
able to resolve this.
He has not, Your Honor, and if I may, I see my time's up, may I?
But I'm just, but just to the point there is, I mean, if you really want to put something, you say he's 78, and I know it, you know, to be in that area to say, you know, you don't have forever, and you gotta understand that if you want to bring a case through the federal courts, by the time it gets to us, that's not tomorrow. It's gonna be a year or so down the road, and you don't know, even after we hear it, you don't know when you're gonna get the opinion. I mean, we work fast here, but you don't know, even then, if it's to your benefit, there may be other issues that have to be dealt with, but you tell me there's a process he could have pursued. County may not want to support him on 5 or 6, but it never said it wouldn't support you on 3 or 4. 3 or 4 would get you at least the interim. He could have a house on that property now. If a greater possibility right now, but right now he doesn't have a house on that property because he's in court and has yet to ask for this amendment.
Yes, Your Honor, and if the legislative amendment process was guaranteed, I think my client would have absolutely gone through that.
Nothing is guaranteed. This is not guaranteed. In fact, if anything's not guaranteed, is winning in the federal courts is not guaranteed. This is the method he chose. Having a choice of going a legislative process with an amendment that, you know, as Judge Keenan has indicated, you know, it is something we've done with some degree of regularity over the course of a year, whatever they do it. Bringing it here, you know, as much as I like to believe that things that you can get, that we are for justice, and we are, but this is not the place to come when you want something immediately and under these circumstances, when there is a viable alternative that you could pursue. And it wasn't. That's troubling in this case. And particularly because when you use the term legislative amendment, you first look at it and says, well, oh, you got to go to state legislature, a bill. Oh, no, that's not what this is. This is a local type thing. I mean, it's more like a Board of Adjustment type deal here where you want to alter a zoning type thing or alter something that's within it. And maybe the word isn't routine, but it's done, and it wasn't pursued at all.
Yes, Your Honor, and that is, you are absolutely right. The one thing that I will say is that still would not deprive Mr. Walls of coming to this court and invoking this court's authority to award him
The question that's being asked is why we should jump into the middle of zoning and land use law when there are a variety of other state remedies that might be more expeditiously pursued. I mean, there's historically, zoning and land use law, they're not on the periphery of state law questions. They're right at the core of it. They're right at the heart of it. And why should we be jumping into that unless the state process is malfunctioning? But, you know, each of my colleagues has suggested other avenues that might be pursued that would result in either a clearer controversy or you get what you look for. But this seems to me to be a rather unsuitable and premature invitation for us to just try to rework the minutia of Prince George's land use law. At any rate, you've got some additional time for rebuttal, and if my colleagues have any further questions, they can ask. Thank you.
Thank you, Your Honors.
Mr. Murray?
Good morning, and may it please the court. My name is Andrew Murray. I represent Prince George's County, Maryland, and as former director of the Department of Permitting, Inspections, and Enforcement, Ms. Melinda Bowling. We're here today, Your Honor, because the plaintiff in this case, Garnell Walls, prematurely filed a takings action in the United States District Court for the District of Maryland, alleging a regulatory takings prior to having ever received a final determination from the permitting agency on an application for an interim septic system waiver.
I'm trying to visualize, and maybe this is outside the record, but at least it helps to understand what we're, contextually, what we're dealing with. This is a partial property. It's like 2.5 acres or so.
I believe it's on the upwards of 3 acres, but yes, Your Honor.
And there are other houses around it, or is it out there by itself?
Well, it's a great question, Your Honor. It's in an area of the county that was formerly rural, And as my counsel alluded to, Mr. Walls has owned this property since the late 1970s. And as I'm sure everybody knows, since that time, suburban sprawl in Prince George's County, which borders the District of Columbia, has crept southward. And there are now subdivisions in this south area of the
So
county.
this is a growing area.
It's a very quickly growing area. It's an area that the county has redesignated from sewer category 6, which is rural and septic systems and water provided by wells, to category 5, where they are expecting future development in the area.
So
and
one of these days, there's gonna be a sewer line running past this property.
Absolutely, Your Honor.
It just hasn't happened yet. You
That's
think?
right. That's exactly right, Your Honor.
All right, I think I have an idea.
That's
But
exactly.
it can't, here's the other thing, I grew up on a farm, so I kinda asked these questions with you and
Sure.
stuff. I take it this land perked, which means he could put a sewer, but you won't let him put a private sewer line on it because you're required to be connected to a line. Is that right, or what? How's it go?
Well, I don't know that the health department came to a final conclusion on whether or not he could put in.
I mean, that's what most people do. You
Yeah,
can't
no,
get on,
he-
you go out there and put
his-
your well in the
his
ground.
property perked.
And you perk the property,
His-
and you got sewer and water out there, and you just independently do it. That's what we did on our farm. But
That's what I
but
have.
when the
Judge.
city comes in, then they want you to get a line, and so he could, all I asked was, he could do this, but you won't let him do that because the requirement is that he connects into the city line, but your city line would cost $2 million to get to it.
Correct, unless, and then this is why we're here, we're talking about this waiver provision, and that's why it's called an interim.
Who can give a waiver?
Both depending on the circumstances, the director of the Department of Permitting, Inspections, and Enforcement, or depending upon the path applied for, ultimately the county council via a plan amendment. And so there are these two avenues. Mr. Walls chose the one avenue that.
Well, last question on that.
Yes, sir.
Do you, again, it's just a curiosity. Do you just give these things as a matter of course sometimes to people? I mean, you're dealing with rural people. He's got this acreage out there. You know it's gonna take $2 million. It seems like to me, it's pretty simple. Says, oh, go ahead and put your septic tank out, or maybe conditionally until we get a water line in, then you would be required to get in. Are there instances you do that?
Absolutely, Judge, and I think that's what.
Why didn't you do it here?
Well, and the letter the letter that is the centerpiece of this action, the February 28, 2022 letter, explains that. And first and foremost, to receive that interim waiver, he was required to submit to the Department of Permitting and Inspections a record plat of his property. I heard for the first time today that the allegation that the denial of this permit was the last thing that he needed to do to develop his property. The record completely belies that. The letter from the director says, we don't know where you are in the development process.
You're saying that if he submits you a record of the plat, then that might move this forward?
Absolutely, Judge.
Can he do it today?
Yes.
Maybe when it goes home, he might want to submit a
still-
record of the plat to you.
He still has the opportunity to pursue the course.
I'm with Judge Wilkinson on this in terms of why we here on this. This seems like this is more of building permit, plat sort of thing. It really sounds like a state problem. I get the allegation of the takings, it is a constitutional provision, but this is not the avenue many of these cases would go. And my concern would be, what would be the limiting case in a limited person in a case like this? So I kind of got that, but there seems to me, I practiced law now over 35 years ago, believe it or not, as a judge, but a judge that long. But it was in the old days, lawyers would get together and you kind of work these things out for your client and say, well, it doesn't make any sense to do this. It's costing all the money to do all this. And, it hadn't been $2 million you're paying, but you're paying a lot of money. Why don't you just do this? And, I can build a nice house up there and spend his golden years on there, and it sounds like a beautiful piece of property to me.
And we would love for that to happen for Mr. Walls.
Is he the only one having this problem?
Pardon?
Is he the only one in that area having this problem?
No, there are others, but they have opted to go through the legislative amendment process and have in fact obtained upgrades to their sewer category to make them immediately eligible for these interim septic system waivers. So there are a number of successful people, and there are others that predate the 2018 water and sewer plan that are currently on well and septic, and they continue.
My concerns were a little bit outside, but I just, you've helped me a lot to understand at least the context of what we're working with here. And, you know,
The February
at the end of the
28th
day, we want, you know, we're not here to create controversy. It'd be nice to get this matter handled here without us having to get involved in it. But I defer to my colleague.
What I was gonna say is that, Judge Wynn's comments resonate with me. I think he makes some excellent points. But this, I was reading, I've read it several times, the February 28th letter of 2022. It goes into considerable detail as to what you need to do and why. It's not as if they were stonewalling the situation. They said, here's what you gotta do. And in one sense, the letter's a little bit opaque, but in the other sense, it's actually very helpful. At any rate, it doesn't seem to me that the state is out to foreclose state court remedies. In fact, the state has been sort of forthcoming and generous in saying, you know, here's the way to go. Here's what you want to do, and he hasn't done any of them.
Agreed, Your Honor, and it makes this somewhat of a frustrating process at this point. But, you know, suffice it to say, for a Fifth Amendment takings claim, not only must there be finality of a decision, but the contours of that claim have to be defined such that.
I mean, I just cannot believe that you can construct a Fifth Amendment takings claim out of a decision to deny a waiver on a matter of public sewer and water hookups. And the way in which that is done, it not only implicates the state's interest in matters of land use and property, but it also has public health concerns seem to me to be implicated too. These are matters that impact directly public health as to how the water and sewer connections are made. And you have to establish some uniform rules. We can't just say, oh, we'll grant this waiver here and we won't grant it there and everything. And this is right at the core in terms of health and in terms of land use. It's right at the core of state authority. And it's not only right, but when it gets when it gets to be right, there's still problems about Burford abstention, but they don't have to be resolved right now. The only thing that's before us is whether this case is right, given the number of state remedies that were available but not pursued.
Correct, Your Honor, and parenthetically, I would note, and I'm sure my colleague will confirm when his time for rebuttal is, he actually did, following the dismissal of his complaint, Mr. Walls did file a parallel action in state court, which is presently before the appellate court of Maryland, but he has not followed these he filed another lawsuit, I guess is what I'm trying to say, in state court. He has not followed the procedures outlined by the director in her letter of February.
Well, where is the state court lawsuit now?
It's the Circuit Court for Prince George's County dismissed it primarily for the same reasons that the district court dismissed it, and it's now before the appellate court of Maryland. pending appeal. So how that impacts a Burford analysis at this point, I don't know if it renders it moot or not, but
Well, we just have a simple
Right.
matter really of whether this is ripe, and then affirming the dismissal for warrant of ripeness will give the, I think will give the Maryland courts the chance and the chance to make their own ruling with respect to this whole issue, and how they make that ruling would seem to be very informative and helpful to us. Affirming the dismissal on grounds of ripeness it seems to me, has the advantage of allowing the Maryland courts to pursue their, without any formal abstention ruling. It allows the Maryland courts the time and leeway to make their decision, which is bound to be helpful to us. And the district court can, if an amended complaint is filed, because the dismissal, I guess, was without prejudice, the district court can actually stay its decision pending the what the Maryland courts do. And so that's the way it seems to me cooperative federalism is supposed to work. Short of abstention or certification, we have formal doctrines which get it over to state court, abstention and certification being the two most prominent. But federalism can work in all kinds of ways, and respect for state courts can work in all kinds of ways. And one of those ways is saying that it's not ripe here, and goes back, and then the state courts, we're signaling the state courts, this is an area in which you have preeminent concerns, and we want to hear what you have to say, and it's going to be very helpful.
which is what I think the district court essentially said in its opinion, Your Honor.
Because this is a health issue. It's not just a land use issue, although it's significantly a land use issue, and trying to say, well, this is the refusal to grant a waiver on something like a water connection is a regulatory taking. That's a real stretch. And and then when you get past that and you get into the health implications of it, and the need from a health perspective of having uniform standards with respect to these sorts of utility hookups.
Which is what the county is trying to do, Your Honor, and
They're trying to have a uniform system, and
Right.
why wouldn't they at a time of rapid, as you pointed, rapid suburban growth
right.
and rapid suburban sprawl? It's all the more reason why Maryland and the Maryland courts and the Maryland legislature and everyone else would want to have a uniform system without us jumping in and say, oh, give this guy a waiver. And that just creates all kinds of kerfluffle and everything within the Maryland system. It makes us look bad too, justifiably.
And as the court correctly notes, that this uniform system, this 2018 water and sewer plan adopted by the county and the county council has to be approved by the Maryland Department of the Environment. So it is a statewide policy, albeit there are nuances to the different counties depending upon their particular development phases. I think that the district court painstakingly analyzed the cases on what constitutes a final judgment and whether or not Mr. Walls plausibly pled futility in this case. It concluded he did not. We of course concur in that assessment. And I would close, Your Honors, by saying that you can't have a Fifth Amendment taking if Mr. Wall's development would have been barred by other obstacles. In other words, and what I said, my initial comments were that I'm hearing for the first time the allegation that the claim that the denial of an interim well and septic was the last phase of his development proposal, the last thing he needed in order to successfully build his home, because the letter of February 28th, 2022 completely refutes that. The health department letter indicating a successful perk that he relies upon at extract page 73, while it confirms that he had a successful perk, it goes on to list any number, A through K, reasons why there are additional things that must be satisfied before he would get health department approval for a septic system. On page 5 of his brief, he claims that he submitted a waiver to the health department, which is the wrong agency. The form for the waiver is DPI, and he claims that he paid a fee of $472.50 when at JA 52, the fee schedule per the 2018 Water and Sewer Plan for an interim septic system waiver is $550.
Is the opinion of the district court, or the reasoning of the district court adequate, do you think, or is that something, would we have anything to add? I mean,
The point I'm making, Your Honor, is that the district court bent over backwards to find that he actually applied for this permit. I find that a dubious proposition at best, but it fell back on no final decision, and you failed to meet futility.
It says all we can do is make a mess of things. That's what all we can do, is just make a total mess of it.
Right. And unless there are any further questions, Your Honors, I'll cede, I think, my remaining 2 minutes.
Judge,
Thank you.
okay, we're fine.
Your Honors, I would like to start with the Fifth Amendment takings portion with respect to state remedies. The United States Supreme Court made clear in Nick that that state remedies are irrelevant for purposes of a Fifth Amendment takings claim. Now, I will note that in the context of land use, it is ideal for state courts to decide specific things with respect to land use. The interesting thing about this case is we had the district court judge who said there was no finality because a waiver had not been submitted. We followed the district court's decision about refiling it in the circuit court. The circuit court judge initially disagreed with the district court and found that there was finality, that there was an application submitted, but determined that the statute of limitations was not right. The district court later entered an opinion after we did a motion for reconsideration, because we argued that the statute was told while the case was pending in federal court, and the district court then ruled that the case was not right, but did not explain the decisions for that. But it put the client in a catch-22. We have one court who's saying, and again, this is at the pleading stage. The record has not been developed. This is the pleading stage, just based on the allegations in the complaint. Our client has said at paragraph 40 in the complaint that he submitted the application. He went through this process back in 2018. In 2022, he received the letter. The regulatory takings occur at the point in time. The entire point in this case is that DPI's own interim waiver application states that he is eligible for the waiver. And all they had to do, our argument in the entire case is that DPI got the decision wrong about whether it had the authority under law to grant the waiver. Its own application says it does. And at the time that the initial complaint was filed, there were no other ones who went through the legislative amendment process that we were aware of at all. By the time we filed the amended complaint, there were 3 people who were going through the legislative amendment process. And this is the first time I'm learning that they were actually successful. The entire point is that the Fifth Amendment taking occurred at the point in time that DPI's director arbitrarily and erroneously decided that she did not, or the agency did not, have the ability to grant an interim well and septic system based on their own regulations in their own 2018 water and sewer plan and their own waiver application. That's what the entire case is about. Our client was prohibited from using his land whatsoever because DPI had decided that it did not have the authority to grant the waiver, when its own application says so and the state statute says so.
Right, but Ms. Bowling's letter also specifically stated that, excuse me, after saying he did not meet the criteria for a waiver from DPI, that if he wanted to pursue the option of an interim well and sewer system, that he would have to pursue the legislative plan amendment process. So she wasn't, the government was not closing the door on him. And don't you really have to have that in order to pursue your takings claim? Why not?
No, Your Honor. It's whether or not the agency. So the agency is different from the legislative body, right? The county council and city council. It's whether or not the agency has dug in its heel and made a decision about whether someone can receive a permit or other benefit. And in this case, the amended complaint makes sufficient allegations that the agency, including the letter from Ms. Bowling, makes clear the agency dug in its heels and determined that our client was not eligible under the agency's process to receive a waiver, and that any other state administrative remedies are irrelevant for purposes of the Fifth Amendment takings claim.
Why don't we can just wait for the Maryland Court of Appeals to resolve this? We don't.
In your honor, I am completely fine with that. Our concern is that we would have preferred that the district court stayed the action like we proposed should have happened, to allow the state court so that the statute of limitations doesn't then put our client out of being able to.
Well, that's before the district court.
Yes, Your Honor. I would say that if this court remanded the case and with clear instructions that there would be an entry of stay pending the outcome of the state court decision, that would.
You can make that motion before the district court.
Well, Your Honor, if you affirmed it, then we lose the time. The time's not told.
It's dismissal without prejudice.
Right, Your Honor, but it was in litigation for more than 2 years. That's the problem. We lost. So if that happens, then our client is in, again, a catch-22. He can't then go back for his Fifth Amendment taking claim because the statute would have expired.
You
But
can make a tolling argument.
we could make an equitable tolling argument. We
You
could.
could also file for a plan amendment, couldn't he?
We could file for a legislative amendment.
That just seems to be the most obvious way to go.
Well, after today,
Yeah.
this might be something that I can use to convince my client to do that while things play out. I would just ask that Your Honors, if Your Honors would consider remanding the case for entry of a stay to preserve my client's rights so he does not lose the rights if the state court decides that, in our favor, that the director of DPI actually did exceed her authority or get the case wrong, at which point he would have been able to get the interim.
But I think that's a tolling question that isn't before us. I just don't want to remand with a whole lot of instructions and everything, because I'm not sure what the state of play is going to be.
Understood, Your Honor.
All right. Thank you, sir.
Thank you.
We'll come down and greet counsel and let's move into our final case. Torres, who's bringing the initial appeal?
I believe I am, Your Honor. We were the first appellant to the plaintiff.
Pardon me?
My understanding, Your Honor, is that we filed the first appeal. We were the first in time to file as the plaintiffs, and so I think the parties understood that the plaintiff appellant would argue first.
Are you Mr. Torres?
I am Mr. Petzold on behalf of Mr.
Okay.
Fitzwater.
Well, who brought the first appeal? All right, well, then you should go ahead and argue. We'll let them argue the cross appeal,
Yes, sir.
okay? Now, did you submit the 28J letter?
Yes, Your Honor, I did.
Why was that submitted to this court on the Monday before, this is Wednesday, before oral argument?
Your Honor, that case is not,
The 28J letters are supposed to refer to cases that are decided after briefing, of which counsel was previously unaware. Now, when was the case that was in this 28J letter decided?
I believe it was decided in 2021, Your Honor, which is.
All right, it's been out there for a long time, and it's not supplemental authority. Now, why did you wait until 2 days before, or 1 day before oral argument, that jammed the opposing party into having to make a quick response while he's trying to prepare for argument? Why did you wait if that case was available to you in 2022?
Well, Your Honor, my understanding is that the purpose of that 28E, 28J was to bring additional authority even after oral argument.
You could have included that case in your briefing, couldn't you?
It was decided after the case went to trial, I believe, Your Honor, but yes, it
All right,
does
but
relate.
before you briefed it, before you filed an appellate brief, it was been
Yes,
out
Your
for
Honor,
a
it
long
was.
time.
Yes.
Well, did this use of 28J authorities just result, I just won't put it in our appellate brief, I'll just throw it in on a 28J at the last minute, so as to throw my appellees off guard? And it's too open to gamesmanship and to approaching this court with briefs and dribbles and the rest. That should have been incorporated into your appellate brief and not submitted to this court on 2 days before oral argument to jam the opposing party with a 28J letter right before they're trying to prepare as you are. Do you understand why that did not strike me in a favorable fashion?
I do, Your Honor.
All right, proceed.
This case, may it please the court, Your Honors, is brought by the appellant, Benny Fitzwater, and the others. I'm Sam Petzonk, and I'm here with Bren Pomponio for those appellants. It's a case about fraud by a fiduciary and the availability of remedies under ERISA, specifically the remedy of reformation, which was awarded by the district court after a bench trial.
Who specifically are you representing? I'm looking at the sheet here and trying to determine, because it's kind of odd.
I represent Fitzwater and the coal miners who were the beneficiaries of this plan.
Okay, so you're representing, okay.
And I am an appellant and an appellee as to the non-prevailing,
For the two?
yes.
The three
But he's
four,
doing
so-
the cross appeal.
He's done a cross appeal, yes.
Okay.
There are appeals going both ways here. Because we won a verdict for 2 out of the 7 plaintiffs at trial, and I will address the others.
I understand.
The district court, despite finding fraud, the district court deprived most plaintiffs of a remedy. The issue on the appeal is whether the district court erred by imposing additional elements to the claims of fiduciary breach and discrimination. The district court held.
So let me understand, in terms of the cause of actions here, the claims experience under ERISA, you're not bringing that, at least, I guess, at this point, that's, or maybe even equitable tolling against Jack on this claim, but it's primarily, we're here on the breach of fiduciary duty, and there are 6 plaintiffs here. 4 of which, 2 of who prevailed below, and the 4 that didn't.
That,
Yes, and the
That's-
question is whether that was properly determined by the district court. That's the narrow view that we're gonna have on appeal here.
well, there are 3 issues on appeal assignments there. First has to do with fiduciary breach. Second has to do with discrimination, the count of claims based
Well, that's what I wanna
discrimination.
know. Are you gonna spend some time on that, or are you gonna focus primarily on this fiduciary breach? I can say you probably ought to spend it on fiduciary breach from my perspective, but I can't speak for my client, not for my colleagues here.
I agree, the error is clear-cut on fiduciary breach. This court should
I didn't say it was, you're not agreeing with me saying that. I'm simply saying that seems to be the determinative fact. The district court, looks to me,
Yes.
really did a fine job of parsing these cases, these things out to determine whether or not there was some injury here, whether there was detrimental reliance on it. And therefore, which the court says no, and then 2, yes. And looks pretty good to me, what the district court did, so maybe, at least from my perspective, you can tell me why that district court was not correct, or at least our review of that should not affirm it. I'd like to know.
The district court confused the elements of equitable estoppel with the elements of showing fiduciary breach. The cases the district court relied on for the requirement of detrimental reliance are estoppel cases, not fiduciary breach involving other remedies like the
So
remedy
you're
of.
gonna have to go through each one of these, aren't you? Each one
Well,
of
I
these.
can tell you, Your Honor,
Because each one is sort of independent, the basis he gave for holding on it, right?
no, he found fraud as to, the court clearly found that the defendants engaged in fraud by telling workers they would have retiree benefits for, if they worked for 10 years and reached age 55. And by,
But this was a result of a 7-day bench trial. And I'm just not particularly inclined to casually overturn the the results of a 7-day bench trial in a case which, at least partly, is due to equitable factors. The breach of fiduciary duty claim was whether there was an unreasonable reliance on misrepresentations with respect to the lifetime duration of the benefits and what have you. And it seemed to turn here on whether there were reservations of rights and whether they were fully informed of that. And so the district court parses it very clearly and says, well, with respect to 4 of these plaintiffs, if you look through this, the seminars and the writings and everything, the company was very, very careful to include language that clearly reserved its rights. But with 2 of them, there was no such reservation of rights. And why wouldn't that question of reservation of rights be a very important factor in the outcome of the 7-day bench trial?
what the district court found is that the fiduciary breached its duty by misrepresenting the reservation of rights, saying that's only lawyer talk. We may reserve the right to alter these benefits, but only for your benefit as the beneficiaries of our trust. That was part of the fraud here. It was a decades-long scripted presentation that Consol, through its HR department, provided to its workers. And the district court erred because none of the cases relied upon by the district court required detrimental reliance for the remedy of reformation, which is the remedy the district court afforded. Burstein was an estoppel case. Unisys was an estoppel case.
On the question of detrimental reliance, wouldn't that be, sort of associate myself with Judge Wynn's comments that looked pretty good to me. wouldn't that be a detrimental reliance? Wouldn't that be a determination with a significant factual component?
No, Your Honor, the requiring a showing of detrimental reliance is not an element of proving fiduciary breach, and that's where the court erred. In Amara, the Supreme Court clarified that material fraudulent suppressions or materially affecting the substance of the agreement between the parties is the predicate for reformation. Misrepresentations causing harm by a fiduciary
Well,
represent
did
fiduciary.
you argue in the district court that you did not have to meet the detrimental reliance standard?
Yes, we did, Your Honor. We did argue that, and the judge disagreed
Okay,
with us.
At what stage did you argue that?
Well, we argued that.
Not that you disagreed as to whether there was detrimental reliance, but did you argue that you did not have to meet that standard?
Yes, at summary judgment, we discussed Pierce against Chrysler Group, Osberg against Foot Locker, the same cases largely that we've briefed here. And those, Pierce against Chrysler is a Sixth Circuit case, which was a reformation case. Unlike the authorities relied upon by the district court, which were estoppel claims, detrimental reliance is traditionally required for a showing of equitable estoppel, Your Honor, at equity, but
So you're saying
for,
the district court relied on equitable estoppel for this ruling?
we didn't plead equitable estoppel, and the district court expressly
Or
found
did
they.
you argue to this court that that's what, I mean, you haven't argued to this court that the district court did that it relied upon equitable estoppel to justify the relief that was ordered?
Well, the district court confused, the district court required detrimental reliance for a showing of fiduciary breach, but that need not be demonstrated. And in fact, our plaintiffs did rely, they took action, they worked for 10 years, reached age 55. They were the beneficiaries of a trust. As a fiduciary, you're not entitled to intentionally mislead your beneficiaries to their detriment.
But that, again, whether they were intentionally misled or whatever, the intentionality of it and detrimental reliance, all of that seems to be stuff that would come out in the 7-day bench trial, with the ultimate decision turning on the fact of whether your clients were mistreated or dealt with unfairly in some kind of way. And as I say, this matter has a significant equitable dimension, and a trial court judge is able to get a hold of that kind of equitable dimension in a manner that an appellate court cannot. And I haven't seen anything that was sort of hit me intuitively as being wrong about what the district court did.
Well, what's wrong about it is that he required a showing of reliance. Let me say that this court, in the Amara case, which has been applied by this court several times, the Amara case does not require, it did not contemplate a showing of detrimental reliance, and this court has addressed surcharge and disgorgement in the Pender cases. The detrimental reliance was not required in the Pender cases. This decided several times by this court. Detrimental reliance should not be similarly required in a reformation claim for fiduciary breach. It wasn't required in Pender. It shouldn't be for disgorgement. It shouldn't be required here for fiduciary for reformation, remedying fiduciary breach, and that's
So
our.
it all comes down to, I mean, as you go down to each one of them, you take someone like Long. He knew his benefits were going to be terminated at any time. He was one of those ones that came up and says, yeah, I know this. But he kept on with it. So the question is, it's almost like a harm analysis is, okay, well, how you didn't rely upon this. You knew they could change this policy at any time.
Well, the question, and this gets to our second assignment of error regarding the discriminatory fashion in which Consult terminated the benefits. When they terminated the benefits, they eliminated the retiree plan. They took the funds from that had secured that plan.
So you're saying all this hinges on discriminatory intent?
Disparate treatment of the retirees. When Consult terminated the benefits, they gave a preferential payment to a small subset of the most recent retirees.
Right, but
And
what was the evidence that that was pretextual?
the evidence was the testimony of the fiduciary, Kurt Salvatore. He testified that the excluded group of retirees had, quote, received the benefit for a period of time, and that the thinking was, that was at JA 207. At JA 292, Salvatore said, for the retirees that existed that time, if we extend the benefits for 5 years, most of them will have hit Medicare age. We will honor, and he believed, as the set law, we will honor our fiduciary duty.
What's wrong with that? Every program has those who are eligible and those who are not. In this case, it seems to me that you have a one-time payment, and it favored those who were less likely to be able to rely on Medicare or whatever, and so it favored the younger people. But why don't you explain on rebuttal why that was wrong, okay?
Yes, Your Honor, thank you.
Mr. Pizzani, let's hear from you.
Mr. Torres. I'm Joseph Torres, Your Honor, representing the defendants. Let me start where you all began this discussion regarding detrimental reliance.
Is it required?
I'm sorry?
Is it required?
It is, and in fact, Your Honor, I
The
think,
opponent says, no, that's not something he should have been doing. I don't know where it came from, because it wasn't in his open brief, but maybe those supplemental authorities that were submitted might have had it in it.
well, Your Honor, I'm
But
looking at,
I think that's a focal point to start off, is a question of, is detrimental reliance something the district court erred in considering in terms of the breach of claim? And then it seems to me, if you're representing, just with the four, that's why I said each one of them has a different type of reasoning that the district court meticulously, I thought, went through it and articulated the reasons. And maybe there might have been something I could have thought a little differently about, but I thought it was pretty straightforward.
yes, Your Honor. To start with the question of detrimental reliance, if you look at plaintiff's own brief to this court at page 34, they admit that detrimental reliance is an element of the claim that they brought. They specifically say to prove detrimental reliance, a plaintiff must establish several elements, specifically among those detrimental reliance, citing to George versus Duke Energy, District of South Carolina, 2008. I would also point out, in response to Judge Keenan's question, that in the plaintiff's findings of facts and conclusions of law before this trial even commenced, Section 7 of their findings of facts is entitled, Plaintiff Detrimentally Relied on Defendant's Misrepresentations. And if you look at page 10 of their findings of facts and conclusions of law, they again state, before the trial even began, it's paragraph 47 of their proposed conclusions, in order to establish a claim for breach of fiduciary duty based on alleged misrepresentations regarding coverage under an employee welfare plan, a plaintiff must prove, among other things, element 4 they list is detrimental reliance, citing to the Bernstein case from the Third Circuit, along with Adams versus Freedom Ford.
What is our standard of review of the district court's determination whether there was detrimental reliance?
Clear error, Your Honor.
So, and as you look at each one of these, you may take a different position on a couple of them. I mean, it's very difficult to come out and say the district court, after going through and articulating these reasons, committed a clear error.
Yes, Your Honor, and I would agree that as to the individuals for which he concluded that they were fully aware of the reservations of rights, there is no clear error in the record that those individuals did not detrimentally rely on any alleged misrepresentations that were made to them.
But you don't like what he did with the other two.
Yes, I do, Your Honor, and that's based on two decisions of this court that look at the requirement that to show detrimental reliance, you have to show that you actually incurred some harm. Your evidence has to be non-conclusory, non-speculative. And with respect to Mr. Bright, the court simply found that after he had heard at a retirement seminar that he would have retirement benefits The sole factual finding in the record is that then Mr. Bright began planning his retirement. There's no findings with respect to Mr. Bright that he did anything to his detriment, that he forwent a more lucrative job opportunity, that he opted to retire earlier than he might otherwise have done. There's no evidence with respect, the judge made no findings of fact as to anything specific Mr. Bright did in reliance upon these alleged misrepresentations. And the same is true for Mr. Prater.
So you need, if you, and I agree with you, I don't see how this could not be, detrimental reliance could not be an important part of the equation here. I agree with that. But that means that you've got to accept that for purposes of the cross appeal as well.
Absolutely.
And so, for purposes of your cross appeal, there was a factual finding on detrimental reliance made on those, and found that there was a breach of fiduciary duty because he had an obligation to administer this, these funds in the interest of the plan participants and everything, and there was detrimental reliance on the false representation of the lifetime duration of these benefits. Now, you've had your arm around the district court's shoulder on the purposes of the direct appeal, and saying, oh, this is factual, this is clearly erroneous, and I'm saying, yeah, all right, I got you, so what are you bringing your cross appeal for? Because he made a very careful thing that there was no reservation of rights, that these people relied on what was a false representation, and if we're gonna, I mean, you know, what's good for you in a direct appeal is just kind of really a problem when you get over to your cross appeal, so why are you bringing it?
Well, I don't think we're talking out of both sides
You're
of our
meeting
mouths.
yourself going in common.
I disagree, Your Honor, because there's a critical distinction between the 4 plaintiffs that did not prevail and the 2 plaintiffs that did. For those individuals that did not prevail, the judge made very specific findings about their awareness of a variety of reservation of rights clauses that precluded them from detrimental relying on other statements. That's the judge's findings, and we agree with them.
But all these cases were consolidated, weren't they?
Yes, Your Honor.
Okay, and they all went to trial together, didn't they?
We sure did, Your Honor.
So, you know,
But Your Honor, what I would say that where we part with Judge Copenhaver's analysis simply goes to the findings of fact that he made with respect to Mr. Bright and Mr. Prater on the issue of detrimental reliance. In this court, in DAK Americas and Damiano, which are the two cases we cited to this court, they found that similar evidence from plaintiffs was insufficient to establish detrimental reliance because there was no specific evidence of any actions they took in reliance on the statements. And we submit.
Well, you've got Prater, they say he accepted that job
Mr.
because he was assured of the lifetime benefits. Why is that not? He said he was instructed to disregard that fine print up there, and he relied on these assurances to accept the job. Prater is a tough one for you.
Your Honor.
That one is, you can walk with that as much as you want, but that's a tough one for you. I know why you jumped on Bright. That's a closer call, but Prater, at least in terms of the facts that the judge made, that challenges, that's a challenging situation.
What I would say about Mr. Prater, Your Honor,
Yes.
is that accepting a job that he admitted did not have retiree medical benefits does not show him taking any action to his detriment.
He said he
It may have
accepted
cost-
because he was assured he would get benefits. And that little fine print, he was told, oh, don't, I guess I'm not sure that's where the lawyer talk stuff came up, but just, disregard that. And he relied on those, this is his testimony, that when he accepted the job. The ones who didn't get it are the ones, all of this evidence seems to come from the individuals themselves. I don't know, so it tells me they weren't coached if they were coached, they, in terms of what to say. I mean, you get up and say, I knew about it, you couldn't get it. Yeah, like Mr. Long, you're not gonna get it, because you basically say you did not. Or if you decide you're gonna go and switch over as Mr. Fitzwater and, join the union side of it, oh yeah, I mean, those are ringer cases right there. But in both of these instances, just as the commonality you indicated with the four, in both of those instances, there's no indication that that fine print is something that they had before them. In fact, Prater himself says he was told to disregard it, and then there's no evidence to suggest that Bright even knew the stuff was there. But that he did, there's evidence that he planned his retirement based on the expectation of lifetime benefits.
Yes, Your Honor.
That's a detrimental reliance. If you're somewhere and you see you have lifetime benefits now, even if you read something that says it can change, but if I retire, I got some benefits, and then all of a sudden, boom, you don't, and isn't that detrimental reliance?
I would disagree for these two reasons, Your Honor. With respect to Mr. Prater, the acceptance of the job did not include, there's no evidence that in offering him the job, they said anything about disregarding any other language. That happens in a subsequent orientation. So our point is that the only finding that Judge Copenhaver made with respect to Mr. Prater's detrimental reliance is that he accepted a job because they told him he had these benefits. And I would submit that accepting a job does not demonstrate any detrimental reliance because he was not foregoing some other opportunity.
Well, I mean, the question is, this is all factual material. The question is, you're trying to convince me as a matter of law that acceptance of a job based on a misrepresentation is not detrimental reliance? That's not your position, is it?
Our position, Your Honor, is that to
It
show.
goes to why did he accept the job? Did he accept the job in reliance upon the representation, or did he not? And that's factual. That's factual. That's not us.
We're not challenging the reliance piece of this. It's the detrimental piece that's missing. The Fourth Circuit precedent that we cited specifically says you have to show not that you just did something, but that you did something that caused you some harm. That's the detrimental aspect of the analysis.
That's heavily factual.
Well, but if the only conclusion,
Matters of causation are factual.
there is causation to show that he relied on it to take some action. There is no evidence of causation to show he suffered any harm as a result of accepting the job. Similarly, with respect to Mr. Bright, the single line of testimony that Judge Copenhaver relied upon was Mr. Bright saying, after I heard this statement, I started planning his retirement. What did you do? What did you do to did you retire early? Did you opt for a different level of benefits because you believed you were entitled to something? If you look at the DAK case and the Damiano case, these are exactly the same types of findings that this court found to be lacking because there was no evidence of any actual harm that these people suffered
Okay.
as a result of it.
What about Mr. Long? I know Mr. Long acknowledged he knew about the reservation of rights clause, but isn't there also testimony in the record that he privately talked to a consul rep who told him that this reservation of rights language wasn't an issue? And he did detrimentally rely in that he turned down coverage from an employer due to the representation that he had it with consul. So it seems to me that at least that gets closer.
I think the specific findings Judge Copenhaver made with respect to Mr. Long was, I don't think it's going to be an issue. But he found that there was no specific representation of Mr. Long that he would have lifetime benefits. The other problem Mr. Long has is that my client didn't terminate his benefits, Your Honor. He was transferred, he went to another company called Murray Energy, and the evidence is in the record that they're the ones who terminated his benefits, not consul. So Mr. Long has several problems with his claim, even if the individual made a promise, as you suggest, Your Honor, and I think actually Judge Copenhaver's findings, he draws a distinction between what that individual said to Mr. Long and what that individual said to Mr. Jack.
Let me understand something, at least in terms, again, I'm going back to a context question. There were those who went with the union, and those who went in that venue were able to get benefits beyond what the company did here. Is that correct? In other words, it was a benefit. If you were better off if you went with the union and stayed with the company.
I mean, I believe the evidence in the record, Your Honor, is that the company believed that its benefits were more lucrative than
I
the
understand what they
union's.
believe, but I'm talking about as a result of this, at the end of the day, those who went with the union were better off.
I suppose it's a matter of subjective understanding as to what.
Well, yeah, you get nothing if with the company. Do you get anything with the union? I mean, the company cut you off and says nothing.
Yeah.
You know, with very limited remedies for those that might leave today as opposed to tomorrow.
Yes, Your Honor.
So at the end of the day, all of these company efforts to keep employees from going over to the union, and representations that are alleged to have been made by HR folks the whole time. You know, you got these benefits, lifelong benefit, little print down here, ignore that sort of print, the whole bit. At the end of the day, the very people who relied and believed the company are the ones who are being punished at the end. It's kind of I realize what, the case is a legal case, but I'm telling you factually, it's almost like, why would you do this to people who were loyal to you and who, in fact, stayed with the company? There are people who are like that. They're going to stay with you to the day you go. If you say, I'm with you the whole bit. Then there's some said, no, I don't believe them. I'm going to go over to the union. But my question, and you sort of answered it, but I think the answer is pretty obvious that, you've been better off to go. All of these have been better off going with a union. The union might have protected them a little better than the company, because the company is more of a different type of situation. But I just wanted to make sure I understood the context of what we hear. And even now, as we get down to it, you only have two people that have prevailed. And, we up here on a clear error review. We're going back and forth as to whether this is detrimental reliance. Fellow says he took this job. I only took it because of the lifelong benefits. They told me it would be good, told me to ignore it. I mean, it seems like you want everything on this case. You won this case for the most part. For what I can see, it's certainly not from a fairness perspective in terms of people if they actually heard these things, but to turn it to the detrimental reliance takes away all of the things before it in determining, well, did you say that? And did you do that? We got a detrimental reliance. Did you rely on it? And I thought the judge was very thoughtful and careful in this, and I think you rightfully did wrap your arm around him on the other side, but I think that arm ought to stay wrapped around him on the other side too.
You might just want to take to heart what my colleague Judge Wynn has said, that you're in a winning position and you're trying to disadvantage the people who actually took you at your word. And you're trying to punish for whatever reason those who are most loyal to you. And you might want to think about that at some point in terms of what's going on here. But okay.
I have a rebuttal, and I can come
All
back
right,
to Judge.
make it quick, okay?
No,
Your
no,
time
I
has
was gonna
expired.
say, I have 5 minutes reserved, and so I can answer Judge Wynn's questions about what he just posed, but I'm happy to wait until I come
Why
back on
don't you
rebuttal to
wait,
do
you've
that.
got 5 minutes remaining, and
Yes.
you can make that
Yes,
point.
thank you, Your Honor.
Now, Mr. Torres, you have some rebuttal time.
Judge Wilkinson, you had asked me, how did Consol discriminate if they provided the 5 years of continued benefits that was contemplated by the fiduciary, Kurt Salvatore, in his testimony that I had summarized at the conclusion of my opening. Consol discriminated because in the record here, you'll see Consol did not proceed to provide the 5-year transition that the named fiduciary, that Kurt Salvatore had contemplated as fair and reasonable at the outset.
Well,
The
it seems to
reason.
me that when all the dust clears, they were trying to, treating the younger workers more favorably because they were less likely to have Medicare or Medicaid coverage. And, I don't even know that, I don't know that this is even an ERISA case. We're talking about a one-time payment, and we've got this Port Hudson case that says, no, this doesn't come under ERISA, but the other question is if it's a matter of discrimination or discriminatory intent, that in terms is a factual matter. There aren't any disparate impact. There are no disparate impact claims here.
Correct.
Class certification was denied, okay? Class certification was denied partly for numerosity reasons, but also because they were sufficiently dissimilar, the plaintiffs. There wasn't sufficient commonality. So when you deny class certification and you say that this hinges on a matter of discriminatory intent, and you say that I'm denying certification because the circumstances vary, that throws the whole thing back into a bench trial and a finding of fact, which we have before us here. This was an odd time, I might add, for you to bring a challenge to a denial of class certification. Normally, we get those on an interim basis or right after an interlocutory basis, but it's odd to me to see you challenging a denial of class certification after the case has been resolved.
We did seek the interim appeal, Your Honor, and the court declined to take it at that
Whatever.
time.
It's an odd time for us to be deciding a class certification issue after a trial in which the plaintiffs were dissimilarly situated.
What- Yes.
And the rest, with class certification being denied and with it being an issue of discriminatory intent, that throws it all over into a factual bin
Well-
and into the district court's province,
The
which
co-
he discharged admirably in a 7-day bench trial. And you set that, and that was set up when the class certification was denied and when it was an issue of an issue of discriminatory intent. That made it factual and the findings were made.
The court erred, Your Honor, as to that issue by holding that we could not prove disparate treatment by way of indirect evidence. The court at JA 292, he said, JA 291, he said, there's no direct evidence consult analyze claims experience.
So what are you asking us to do? You're asking us to reverse the
Reverse the
denial?
summary judgment on the,
Reverse the denial of class certification?
No, Your Honor, reverse the summary judgment on the discrimination count because we did show by indirect evidence, by the fiduciary's own testimony, that they knew they were drawing a distinction between retirees who had greater claims experience and other retirees who had less claims experience. And the fiduciary took money and gave it to the least experienced, the least costly retirees and excluded all the other. If they're going to terminate the plan, if you're inclined to uphold the verdict as to fiduciary breach, surely the fiduciary cannot be permitted to make a preferential payment to the healthiest amongst the retirees.
Right, but they gave a different reason. They didn't say we're doing that because they're healthier. They said that they retired with an understanding that the benefits were going to continue till 2019, didn't they? And then the benefits were terminated in 2015.
Right.
And so they felt that these people were the most directly impacted by the fact that their initial plan to go to 2019 was not going to be carried forward. That was their explanation, not we're going to go for the more healthy people.
Well, but the court erred by finding that we could only prove direct evidence of specific discriminatory intent. It's enough to show indirect. We showed here that the fiduciary understood they were creating a category based on claims experience. They were excluding the people who had cost them more.
See, this is what I don't understand. I think maybe you're not being close enough to the record in this case, because wasn't the evidence, didn't the district court accept the evidence that the reason why the more recent retirees got it was not because they were healthier? They got it because Consul had made the representation that we're going to continue the plan till 2019. And then when they decided soon thereafter to cut it off at 2015, they felt that these people were the most closely impacted by that decision, not the retirees who had already been retired for a number of years. Wasn't that what the district court found?
Well, there was a genuine dispute of material fact as to
Yeah,
that.
but
and
isn't
that's-
that what the district court accepted?
that we believe erroneously should not have been resolved at summary judgment. That's the issue on that, Your Honor, that there was a triable question as to whether there was indirect evidence of discrimination. If the court would remand the case with the instruction, for the court to try that question about whether it was discriminatory.
Okay, so the only evidence of pretext, though, from your perspective, is that these people were younger and ostensibly more healthy.
Well, the evidence is that Consol self-insured this plan. They knew that the more experienced folks had filed claims for years. The claims data is in the record here in this case, and the fiduciary knew it,
So how
Salvatore.
does that show pretext?
Well, because, especially in light of
district
the background of the fraud here, the company was trying to get out of the expensive obligation of all that, of paying for the costly claims of retiree health care. And they made they terminated the plan, they pocketed the money, and made a preferential payment that favored a small subset of these retirees.
Okay, and but it seems to me you're just saying it's logical that they did this because it was cheaper this way.
Well,
But is that enough for you to survive summary judgment?
Well, we believe it should be, Your Honor, and certainly the district court also didn't have the, fairness to the district court, didn't have the benefit of any perspective on what claims experience means. It's a term that hasn't really been defined in appeals, in any decision of this court before, so it's somewhat of a novel concept. So we think there was a triable question as to whether Consol discriminated. If I may, Your Honors, just to address the equitable tolling issue, regarding Mr. Jack, the court clearly erred there by finding Mr. Jack's claim arose from the time that he relied rather than the time that he actually discovered the fiduciary
I
breach.
think we understand your briefing on that issue, and that'll be fine, but I think we understand the briefings surrounding the statute of repose and the questions raised with regard to that. Okay?
Okay, thank you, Your Honors.
All right, well, thank you. Sir, okay, you've got 5 minutes of rebuttal here, and we'll be
Yes,
happy
Your
to
Honor.
hear from you.
All right, it won't take 5 minutes. To go back to Judge Wynn's question regarding who was disfavored or disadvantaged here, the record evidence as to why Consol terminated these benefits speak to some unanticipated and serious economic conditions that this coal company and many others were facing at the time. And so I don't think there's any evidence in the record that they were intending to lead people on with the intention of not having these benefits extend for as long as humanly possible. And the fact that they had to make difficult financial economic decisions is what drove this, not some desire to lead them
It wasn't
away.
meant to indicate that they did this for a notorious reason or with bad intent or bad faith. I'm just speaking at the end result of it, that those who chose to go with the union ultimately fared out better than being with the company, and at the end of the game, or at the end of the day, economic factors all considered, at least the efforts to, given the 5 years, if you leave today, I see there were some mitigating efforts there. But ultimately still, those that chose to go with that union appears to have fared out better than if you stayed with the company. And back in the old days when I've seen it happen, small town where someone's going out of business and they go out of their way to make sure those employees who have been faithful and loyal to them all those years would be taken care of, and sometimes even to their own detriment. And I'm not saying that wasn't done here, but I'm just saying at the end of the day, now we're coming down, we've got 6 individuals here, 2, we say, yeah, there's detrimental reliance, at least in terms of may not be clear error on it, and the vigorousness of not even wanting to deal with those two, that's kind of what the matter we're getting at.
I understand that, Your Honor. The only other point I was going to make is this question of going with the union or not. I believe the record evidence is that Mr. Fitzwater had qualified for those benefits.
He went over it. He went on and jumped on board with them, so I guess he's okay. I don't know why he's here.
Well, I don't either, Your Honor, but he had qualified for those benefits before he joined Consol, so it wasn't a question of him going to the union at that point in time. He was just taking advantage of benefits he had qualified for earlier. That was the only other point I wanted to make there. And then Judge Wynn, on the discrimination point, there's nothing novel about this statute. It requires but-for causation, contrary to counsel's argument here. It's a paradigmic discrimination claim where on summary judgment, they were required to actually put forward evidence sufficient to withstand summary judgment. And they didn't do that. All they relied upon on summary judgment were two experts that the judge completely rejected as offering nothing but speculation and conclusory suppositions about why Consol did something. And so there's nothing confusing or complicated about this. It works just like any other discrimination case does. And nothing that counsel offered today shows any error in the judge granting that on summary judgment. And then the only other point I'll make, and then I'll conclude, is that with respect to class certification, I think it's important that we look at what they actually appealed to this court regarding class certification, which was a much narrower question of whether the judge should have granted their renewed motion, which only related to this discrimination claim. And so the standard of review for the judge exercising his discretion not to allow them to have a second bite at the apple is subject to a much higher standard of review than simply going back and evaluating whether or not class certification as to all their claims have been properly denied. We don't think they preserve that for appeal. We think their class certification appeal is much narrower, and we don't think that there was any abuse of discretion by Judge Copenhaver in denying their last-minute renewed motion. So we'd ask that the majority of Judge Copenhaver's ruling be upheld, and you've obviously heard our position as to the other two. Thank you very much.
All right, we thank you very much for your good presentations. I might say, just as a matter of appreciation, that Judge Copenhaver is a centenarian, and from my standpoint, he just gets better every year. What a wonderful man. All right, we'll come down and we'll adjourn court and come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.